we don't have to waste time because, quite frankly, Your Lordship decided this matter when we were here last time. Because Your Lordship will remember that it was raised by Mr. Downer in the context of, you remember, my Lord, when we were making an application for reasons.
Yes.
Yes, Mr. Downers raised this point that we're not entitled to reasons because Section 316 is very clear that, in other words, our appeal is a non-starter because Section 316 is only available after conviction. This court rejected that argument and duly gave us the right to reasons. So unfortunately, again, we have to repeat something that this court has actually decided. Well, here it goes. 316 says that any accused convicted of an offense may apply to that court for leave to appeal against such conviction. That's the first thing. Or against the resultant sentence or order. And Your Lordship made it clear even the last time that that surely means that once a court has given an order, it falls under Section 316. But so that's just a textual thing. But if that is not clear enough, then we all know, my Lord, that the general rule is that Section 316, or rather, an appeal in a criminal matter is allowed if the interests of justice so demand. So in any event, even if there was no textual basis, the mere fact that from time immemorial, our courts, and I don't have to quote authority for this, our courts have said that in the appropriate circumstances, and at least with to give our colleagues credit, in their heads of argument, they cite those cases,
yes,
which say that when the interests of justice so demand, that rule of so-called intermediate appeals is departed from. So the only question, therefore, would not be so much of that there's an absolute bar, because everyone accepts there isn't. The only question would be whether it's in the interest of justice in this particular case. And to that, we say the following, my Lord. It's clearly in the interest of justice in this particular case because it's common sense. One doesn't even have to be a lawyer to understand that. You can't have a situation where you say the prosecutor or the judge, for that matter, must recuse themselves. And then you say, okay, the judge or the prosecutor is not recused. And then you say, no, but let's go to the trial and run with the trial. And then at the end, we'll determine whether the judge or the prosecutor should have recused themselves. That's just, with the greatest respect, madness. Because it would mean you have to run a long trial knowing that it might be a nullity. The Lordship again knows, I don't need to quote authorities to Your Lordship, that a non-recusal that's found to have been wrong renders the entire thing as a nullity. So it would be a waste of everybody's time, everybody's money, and everybody's witnesses and all that. So this is clearly a case where the interests of justice would demand that the appeal should be heard at this stage. So that's the one ground. The second, my Lord, is that in any event, remember one of their attacks is that an appeal that emanates, I'm paraphrasing, from a criminal matter cannot be dealt with under the Superior Courts Act. Now that argument is completely fallacious, my Lord, on two simple grounds. Firstly, unlike the matter that served before Justice Kuhn, the Section 106 application, this application is not the application for recusal is not a criminal matter. So the application before Justice Kuhn indeed arose from Section 106 of the Criminal Procedure Act, and therefore it was one that derives from a criminal matter. But this one is a recusal application. It's a common law application. It's a motion like any other. The fact that it's heard here is because the trial is here. But for all intents and purposes, it's a motion. It's a motion like any other motion. Recusal applications, they happen every day in our courts. And they are, whether it's a civil matter or a criminal matter, it doesn't matter. But they, in their own nature, they are civil proceedings. And therefore, this appeal, whatever the form, substance over form debate, this appeal is an appeal against a civil motion. So it must be looked at through the eyes of the Superior Courts Act as well. And we know that that appeal is obviously available. Because you couldn't say you can't appeal under Section 316. You can also not appeal under Section 17, because that would mean you can't appeal. It would be a deprivation of the right of appeal. I'll leave it there, my lord. There are many other reasons why that so-called point in limine is doomed to fail. But on the basis that this court, as I say, has already pronounced itself on that issue, I will I'll stop there on that point. Then, my lord, once that artificial obstacle is taken out of the way, then we have to get into the issues that we raise in limine. My lord, I want to say this because really this application can be decided on this point alone. Your lordship will have seen that what we say in our second point in limine, which is the first one now, is that another court would reasonably come to a different conclusion simply because your lordship, with respect, failed to address some of the key issues that we raised. Now, and I want to make this very clear, my lord. Mr. Masuku and I will address you on the merits of those issues. I'm not there now. All I'm saying is that irrespective of the merits, whether they're good or bad or indifferent, the mere fact of the non-adjudication of those issues is itself a ground for appeal. And your lordship, again, knows very well that the whole point of having a court system under Section 34 is that everyone, and that includes Mr. Zuma, everyone has a right to have their dispute adjudicated, win or lose, irrespective. And once that right has been deprived, then the right has been deprived. Now, of the issues that the court did not deal with, I will pick out two of the most important. We say one is that the court failed to deal with let's call it the Glenister issue, a very important constitutional issue. Secondly, we say this court failed to deal with the alternative ground for bias, which is always there, which is bias based on a reasonable apprehension for bias. Again, it's trite. I don't need to cite authority for your lordship to know that the test for bias is always twofold. It's actual bias or reasonable apprehension for bias. The old saying that says justice must not only be seen to be done, but rather must not just be done, must also be seen to be done. That second part that talks about seen to be done means the objective test, the apprehension of bias. It means seen by the so-called reasonable person, but also by the society at large. Because the society also has an interest to see that there is justice. We know the devastating consequences that might come if society thinks that there is an injustice, rightly or wrongly. So, again, my Lord, I'm not arguing now the merits of whether there was a reasonable apprehension or not. I'm simply saying the failure of the court to address that aspect, that leg, is in itself a violation of Mr. Zuma's right to have that aspect adjudicated. Your Lordship, we concede, adjudicated the issue of actual bias. But the mere failure to adjudicate the issue of a reasonable apprehension of bias is sufficient, because surely even my learned friends cannot say another court would, it would be unreasonable to say another court will adjudicate those two issues. That would be an absurdity. And as I say, I'm not even saying whether we will succeed or not succeed, but simply you can't say that the court will, to use a colloquial language, just blue tick those issues, because the court can't. The court can't, when a constitutional issue is raised, Glenister, simply say nothing. It either has to say you are right or you are wrong. Now, if that ground, my Lord, is appreciated and anchored in Section 34 of the Constitution, just the right to adjudication, then that should be the end of this application. Because Your Lordship, with the greatest respect, ought to say, look, to the extent that the court did not address these issues and therefore did not give reasons. I mean, the second part follows. If the issue is not addressed, then obviously the reasons for that have not been given. Now, before I go back to the principle, let me explain why this is an easy matter for Your Lordship to deal with. It's easy because the other side agrees. They agree that those issues were not addressed, but they simply do what lawyers call confession and avoidance. So they say, yes, they were not addressed, but the reason why they were not addressed is because they were so hopeless. That kind of submission only needs to be stated to be rejected, because it's not for them to second guess why the court did not address something. Their job is to argue their case, not to give us a judgment. Now they are giving us a judgment as to why the court did not address this or that or the other. So they say at paragraph 72 of their heads, my Lord, they say, in the circumstances, it is unsurprising and with respect wholly unobjectionable that Chili J's statement of reasons does not address, so they admit, does not address Mr. Zuma's hopeless arguments based on Glenister and his alleged reasonable apprehension of bias. So the good thing about that is that at least it's common cause that those issues were not addressed, and we say that it ends there. Once we agree on that, whether it's hopeless or not hopeless, whatever is completely irrelevant. Now, let's then go into their defense, so-called, which is the defense is so-called hopelessness. Now, and again, I won't waste time on this, my Lord. I just want to summarize what those 2 points, which we think are two of the most important legal principles. Glenister, my Lord, as Your Lordship knows, is invoked for the following reasons, and Mr. Masuku will get into the details. I'm not going to waste time on it. But Glenister is only for this purpose, that our reading of that case, rightly or wrongly, is that it sets the principle that a prosecutor is disqualified from prosecution if they have participated in the investigation. I'm putting it at the simplest. Your Lordship knows the intricate details. Now, my learned friends, they say, no, we can't raise Glenister because we did not attack the constitutionality of Section 28 of the NPA Act. Your Lordship will know, I think it's 28.2. That's the section that entitles the so-called investigating advocate to appoint a prosecutor. But that's completely misreading what we're talking about. We do not attack, let me confess here, we do not attack the constitutionality of Section 28.2. We think Section 28.2 is fine. There's no problem with it. In other words, our case is not that it is wrong to appoint a prosecutor as an investigator. We accept that in certain circumstances that must happen. What is wrong, my Lord, is not the appointment of the prosecutor. It is to say that prosecutor who has been appointed must now be the prosecutor in that same case. That's all. He can be a prosecutor in all other cases. He can be appointed lawfully, but he cannot be a prosecutor in the same case that he investigated. That's all. And that law, my Lord, again, sorry, I'm stealing some of Mr. Masuku's points, but that law is not even something that is revolutionary or anything. Even during apartheid, that law was in place. And I'll refer your Lordship to two cases. Both of them are one-pagers, they are very short. 1948, the year of 1948. There's a case, it's called Rex versus Negrini, my Lord. 1948, bracket 4, SA 995.
Sorry, just slow down, please.
1948, my Lord. Yeah. Bracket 4, SA 995C.
Yes.
And it literally has 3 paragraphs, but I'll just read the relevant part. It was de Villiers AJP. The accused was convicted and sentenced to pay a fine of £10 or 14 days hard labor. The record displays a most extraordinary state of affairs, for it would appear from the record itself that the public prosecutor was the chief witness in the case. He was also the complainant in the case, and he was not only the investigating officer, but also prosecuted, so that he appeared in those 4 categories and so on. And then the court says, it quotes another case. It says, if where the prosecutor in a criminal case functions also as investigating officer, delator and principal witness, and as at the present case, which came on appeal from a magistrate court, it is difficult to see how he can prosecute the accused with the detachment and moderation which is in accord with the high traditions of prosecution at the public instance in this country. The key word there is detachment. And the court in 1948 already said that you cannot prosecute. The same sentiment, my Lord, you will find in another case, another apartheid case, S versus Nkushubana. That one is 1972, bracket 4, SA 633E, my Lord. And there again is a short judgment of Adelson J. The first matter which calls for comment is that it appears from the notice of appeal that the only state witness who was also the investigating officer was the prosecutor in this case. This is a highly undesirable state of affairs. Then it goes on. So the point we're making, my Lord, is that in any jurisdiction, in any, as I say, one doesn't have to be a law student or a lawyer to understand that a prosecutor who is an investigator in that particular case is ipso facto disqualified. And that's really the only point we make. which Mr. Masuku will expand on. The point is that that just shows that this defense that, oh, well, the court did not even address that because it's such a non-issue, can't be correct. Because the court may agree or disagree with us, but surely the court has to address it. Similarly, my lord, if you look at the issue of reasonable apprehension of bias, Your Lordship, when I deal with the merits, one of the cases, my Lord, I beg leave to hand up our bundle of authorities. It's a few cases, my Lord, that we'll rely on just for the convenience of the court. But Your Lordship will see that one of the cases, ironically, that we're going to depend on a lot for this application is the decision of this court in the recusal application that was before Judge Kuhn. Your Lordship knows about that. Well, that's how Your Lordship got into this case. That judgment, my Lord, and I have to say this because I have a lot of time and respect for Judge Kuhn. I personally think that is one of the best judges that have been produced, not just by this division, but just across the board. And he gave a comprehensive analysis, as Your Lordship knows, of why he had to recuse himself. So, remember, theoretically, even though Your Lordship is sitting there now, it doesn't matter who's sitting there, it's this court. So this court has already dealt with these issues. And by the way, that alone is a ground to give leave to appeal. Because if this court, per Qili J, has said A, and this court, per Kuhn J, has said B, that means somebody has to say who has right. It doesn't matter who. And that somebody can only be the higher court. But so Qili J said the following. I'm sorry, Kuhn J, thank you.
Kuhn J.
I meant to my learned friend. But as I said, it doesn't matter. It could be the one or the other. He says at paragraph 36, which you'll find at page 15 of the bundle, my lord.
Yes.
It says the perception, appearance, or apprehension of bias is as important as actual bias.
In paragraph 36.
36, my lord, yes. Is Your Lordship there?
Yes.
Thank you, my lord. Yeah. So you can just even stop there. The perception of bias is as important as actual bias. In other words, if there's a case about bias and you just deal with actual bias, you have not dealt with the real pleaded case. And he says, this is because, quote, it is of fundamental importance that justice should not only be done, but should manifestly be seen to be done. Nothing is to be done which creates a suspicion that there has been an improper interference with the course of justice. In line herewith, the Constitutional Court has held that, quote, nothing is more likely to impair confidence in proceedings, whether on the part of the litigants or the general public, very important, than actual bias or the appearance of bias in the official who has the power to adjudicate on disputes. Of course, this deals with judicial bias, but our respectful submission, based on the authority of the Smythe case, which I'm going to deal with later, is that for the purposes of a fair court, it doesn't matter whether you're talking about a judge or a prosecutor. And then there are various other cases. Your Lordship will look at that in his own time. But the key point is that the apprehension of bias is as important as actual bias. And to illustrate this, my lord, you'll remember, my lord, that in the recusal application before Kun J, we had specifically disavowed any reliance on actual bias, as he says in the judgment. We said in that case, we do not come here before this court to say there's actual bias on the part of Justice Kun. We didn't do that. We are saying something different. We're saying there's a reasonable apprehension of bias on the part of the litigant, in other words, on the part of Mr. Zuma, that since Justice Kun had pronounced himself on certain issues, which will arise in the recusal application, he obviously cannot sit. So that case was entirely based on reasonable apprehension of bias. Unlike in this case we do not make that distinction. In this case, we say Mr. Downer suffers from actual bias, but if we are wrong, it's a reasonable apprehension of bias. So that second leg has been left unadjudicated. And as I say, my lord, again, whether we're right or wrong, that there's a reasonable apprehension of bias is a question of the merits. For now, we're simply addressing the fact that such an important leg of the test was not applied. Then the third one, my lord, is not as important as the first two, but I'll just mention it in passing. The third one is that your lordship, in our respectful submission, failed to analyze what we call the cumulative effect of the grounds. Remember, we said, my lord, each of the grounds on its own is good enough for the recusal. But we said if we are wrong, then the cumulative effect is such that those grounds viewed together. In other words, your lordship knows this. I mean, in law it happens all the time. For example, in bail applications, you say, look, there might be circumstances. Each of those circumstances might in themselves not be so-called exceptional. But when you look at them collectively, they amount to. So it's that kind of reasoning. And the support for this, my lord, is that, again, to go back to Kun J, the approach that Kun J employed, you'll find that at page 17 of the bundle, my lord. He says, just in similar vein, the question is whether the alleged paragraph 49, my lord, in the middle. Yeah. The question is whether the alleged manifestations of bias, viewed either singly or collectively, underline that part, viewed either singly or collectively, would give rise to a reasonable apprehension of bias on the part of a reasonable, objective, and informed person. Factors raised, if considered individually, that's the important part, might not in and of themselves be a sufficient indication that a litigant would not be perceived to have a fair hearing. But taken cumulatively, the complaint that is reasonably apprehended, that is, the judge will not bring an open and impartial mind to bear on the adjudication of the matter, might be justified. In other words, Kun J was distinguishing in the situation where each factor taken alone might not be enough, but taken cumulatively, they collectively add up to sufficient. And that's what we say your lordship, with the greatest respect, did not do. In other words, we're saying, let's assume for a minute your lordship was correct that pillar 1, pillar 2, pillar 3, pillar 4 on their own were insufficient. But the failure to do the other exercise, which we had pleaded, is lordship, just bear with me. Sorry, my lord. And before I depart from this point, let me just remind your lordship that these are not matters that we dream up now on appeal. These were matters that were pleaded in our application. So your lordship, if just for that reference, we'll go to page 31 of the original bundle, the trial bundle, I mean the motion bundle. You'll see that this is how we pleaded the case on this aspect. We said under Chapter 1 of the NPA's Ethics Manual, under the heading Conflict of Interest, the following paragraphs bear reference. That's the founding, my lord, I'm sorry, yes, paragraph 65. Yeah. And it's not us, we were quoting the manual of the NPA. It already talks about perception of bias. So it says at paragraph 112, prosecutors should recuse themselves where a perception that objectivity is compromised exists or could exist. That's clearly the apprehension of bias test. That manual goes on to say, at 65.2, we say, a prosecutor should never put him or herself in a position where he or she could eventually become a witness in his or her own case. And I will show later that in this case, there is no doubt that Mr. Downer will be a witness at the trial. There's no doubt at all. In fact, Justice Kuhn said it himself in so many words, but we'll deal with that later. And then, maybe let me deal with that, my lord, quickly, so that we get it out of the way. Your lordship will remember that one of the so-called 14 grounds for the Section 106 application was that Mr. Downer and Mr. Breitenbach were part of the leaking of documents and so on. We know that that's now, there's been a final ruling on that in terms of the private prosecution. But that's irrelevant to the current inquiry, my lord. The fact of the matter is that Justice Kuhn correctly said that those issues must be dealt with at the trial. Now, when those issues are being dealt with at the trial, who are going to be the witnesses? Obviously, it's going to be Mr. Breitenbach, Mr. Downer, Ms. Mon, and maybe others, because the issue will have to be determined one way or the other. That's irrelevant. The fact is that those people are going to be called by us, if by no one else, to get to the bottom of the alleged leakage. And it might even involve the President Ramaphosa, because he said to us, and it's part of the papers, my lord, that the alleged misconduct will be referred to the Legal Practice Council, because it's very serious, and that never happened. So we want to know why that did not happen. But that's not the point. The point is just to talk about Mr. Downer, that he's I cannot tell you now, my lord, a definite witness in that aspect. Anyway, then we say where the participation of the prosecutor in the investigation, and this is the important one, my lord, at 65.3, where is the point that I've already made. Where the manual of NPA says, where the participation of the prosecutor in the investigation process is unavoidable, the prosecutor should not prosecute the case, that case. Yeah. Not that he should not prosecute general. So this is something that we had pleaded, and various other references. So, my lord, with the greatest respect, this court, with the greatest respect, ought to grant leave to appeal based on the non-addressal of those issues, because they are serious issues, contrary to the glib, comment that these are hopeless. How can it be hopeless to say a reasonable apprehension of bias has been pleaded? The issue really is that there was no answer to this. Well, if your lordship is still inclined to even doubt that there is there are compelling grounds why the matter should be referred to another court, or that there's a reasonable possibility that another court would come to a different conclusion, which at this stage, my lord, we have established beyond any equivocation. Then I will deal very briefly with the merits. My lord, let's now go to the merits. We'll do it pillar by pillar, very briefly. My learned friend, Mr. Masuku, as I said, will deal with pillar 4. And I dare say, even before he stands up, that everything I'm going to say now, even if it's shelved aside, if what Mr. Masuku is going to say about the merits of the Glenister rule is correct, then again, that's the end of this application. Because if indeed there is a reasonable possibility that another court might find that this age-old principle about, let's call it dual roles of a prosecutor, needs to be examined in our favor, then again, obviously, that's a disqualification. So again, what I'm saying, my lord, is your lordship should approach the case in 3 stages. Assume, if I'm correct on what I've said about the points in limine, that's the end of it. If Mr. Masuku is correct on the Glenister point alone, that's the end of it. But if those 2 things don't happen, then I'll deal with pillars 1, 2, and 3. Now, pillar 1, my lord, and needless to say, as your lordship actually put it in his reasons, your lordship did acknowledge, I think at paragraph 2, that our case was that if one of those is good, that's good enough. So I don't have to repeat that. So pillar 1, my lord, is about the prosecution, right? And it's shall we say, it is deliberately misunderstood by the other side. What we say, my lord, under pillar 1 is the following. The mere fact that on one day Mr. Zuma is prosecuting Mr. Downer, and then on another day Mr. Downer is prosecuting Mr. Zuma, just that fact is a mockery of justice. Which member of the public will have confidence in our legal system if they see that happening? Because they're going to say, I mean, this same person who was in the dock being prosecuted by this one, now tomorrow the wheels have turned. And you expect that one who was being prosecuted yesterday to be impartial and neutral and objective and all that. It's just ridiculous. And again, in defense of your lordship said the following important words in that respect. And we agree with your lordship. Excuse me. And this, with the greatest respect, again, is the end of this case. Your lordship says, it was argued that if Mr. Downer, paragraph 4 of your judgment, yes. It was argued that if Mr. Downer were to prosecute Mr. Zuma today and then be prosecuted by Mr. Zuma the next day, society would make a mockery of our justice system. That's what I've just said. And this is the important part. Your lordship, this is where we part ways with your lordship. Yes. Your lordship says, if that were the position, then I would have not hesitated to grant an order removing Mr. Downer as public prosecutor. But that is not the position. As things stand, there is no private prosecution. Now, let's just pause there. So what Your Lordship is really saying, in our respectful submission, what another court would come to a different conclusion, is whether the outcome of the private prosecution is of any material relevance. Your Lordship found that it is, and what we're saying is that another court would find that it is not. And let me explain why that is so. In real life, my Lord, it matters not what the outcome of the private prosecution is. The fact of the matter, which will stand forever, amen, is that Mr. Downer was accused of being prosecuted by Mr. Zuma, and now Mr. Zuma is expected to be an accused being prosecuted by Mr. Downer. That fact can never change. Whether the prosecution is good or bad, or he gets convicted or acquitted, is irrelevant. And in fact, ironically, my Lord, Your Lordship will know this just from common sense. Remember, it was said that that prosecution was malicious and what have you. Well, we say that's a point in our favor. Because imagine if indeed the prosecution was malicious, then the more reason why Mr. Downer should be aggrieved and want to get him, because he maliciously prosecuted him. So it's no answer to A, to tell us about the outcome, and B, to say no, that prosecution was malicious, even more so if it was malicious.
Just a moment, please.
As Courtman. Thank you, my Lord. So our point of departure with Your Lordship is on a point which we say is arguable at best. Yeah. So one court might say, Your Lordship is right, the termination of the prosecution does away with Pillar 1. But surely it is reasonably possible that another court would say the outcome is irrelevant because the grudge is not tied to the outcome. And my Lord, to go back to it's page 18. Yes, this is sorry, my Lord, I just want to find the second reference. Justice Kuhn addressed this question, ironically. He says, you'll find, my Lord, this at page 18 of the bundle, at paragraph 50 of the judgment. And this passage kills two birds with one stone because it also shows how Mr. Downer will be a witness. Start with the sentence, the issue. It's the second line, my Lord, from the top. Yes. This is what Justice Kuhn says. The issue of him, that's Mr. Downer, remaining as prosecutor is inextricably linked to the merits of the private prosecution. Specifically, the merits of the criminal charges giving rise thereto, which include whether there was a leaking of medical information, whether the information was confidential, whether it was illegal to do so, whether the provisions of the NPA Act were contravened. So we can take that last one off because the private prosecution is gone. And here's the most important part. It says, whether, even if no illegality, if not illegal, in other words, even if he gets acquitted, and insufficient to result in a successful conviction, Mr. Zuma's rights to a constitutional fair trial would be affected. So in a nutshell, what is Justice Kuhn saying there? He's saying that the issue about the potential conflict is not tied to the outcome of the private prosecution, which is our submission. And the same thing you'll find at page 20 of your bundle, my lord. Oh yes, that's the one I was looking for. 20, paragraph 59. Lordship there?
Yes.
Yes. Now here he says it in so many words that the outcome is irrelevant. Justice Kuhn says, it is undoubtedly so, as Mr. Zuma submits, that irrespective of the outcome of the private prosecution, the fact that Mr. Downer is being or was privately prosecuted will require determination of the question whether he should remain as prosecutor, whether that issue is raised mere motu or otherwise. The answer to that question will not only be objectively important to an accused person in the possession of Mr. Zuma, but will also reasonably affect the public confidence in the judiciary, the NPA, and the general administration of justice. And he says at paragraph 60, the mere fact, and that's really our plea, the mere fact that a private prosecution is being pursued against a prosecutor in a pending trial is a matter of considerable concern and might suggest, perhaps even strongly suggest, that he should be removed as the prosecutor. And then, of course, he says, which we agree, but it is not per se necessarily conclusive. We accept that, my lord. So we don't say that it's an automatic thing, but we're saying the mere fact is strongly, as Justice Kuhn said, an indicator for the removal of the prosecutor. So that's the first respect in which we differ with your lordship, or we respectfully submit that another court would come to a... your lordship then goes on to say, as things stand, there is no private prosecution. We've made that point. Your lordship, with the greatest respect, was wrong in that finding. Because, and our learned friends have given your lordship a chronology. Now, my lord, I can't blame the court for this. This court has got so many freeways and byways and all that sometimes even myself, it's not easy to locate a particular moment. But here's the reality, my lord. Your lordship, on the 20th of March, 2024, when your lordship granted your judgment, when we argued the matter, remember it was the 20th and the 22nd, because there was a public holiday in between. Yeah. At that point, my lord, the private prosecution was alive.
When the matter was argued.
When it was argued, yes. So that's the first submission we make, my lord. The fact that your lordship reserve judgment is neither here nor there. Your lordship could have reserved judgment for 2 weeks, for argument's sake, or could have given the judgment there and then. So what your lordship is then saying in that, he says, if that had been the case, your lordship would not have hesitated to grant an order removing Mr. Downer as public prosecutor. Now, sorry, my lord.
So you see,
I'm saying on your lordship.
Judgment was.
Sorry, my lord.
So when a judgment was reserved and circumstances changed.
No, I'll show that they did. They actually didn't. But let's assume for the current purpose that they did change. Yeah. So even if they did change, the submission would be this, my lord, that your lordship surely is duty bound to determine the case as would have been determined if, yes, if your lordship had reserved judgment, let's say for a week or two, and your lordship will know what would have happened had your lordship reserved for a week or two, because your lordship says himself, I would not have hesitated to grant an order removing Mr. Downer. So, Your Lordship then can't do what is known by lawyers as ex post facto rationalization. To say, okay, I would have acquitted you, but now something has happened and therefore you were guilty at that time. It doesn't work like that. So we're saying that's wrong at that level, assuming the circumstances have changed. Why do I say that, my Lord? And that's borne out by my learned friend's chronology. Your Lordship will remember, and I'll just say this because Your Lordship was here, I don't have to go to town. You remember, my Lord, that the private prosecution was postponed to the 19th of April. That is the time when there was a debate about whether Mr. Downer and Ms. Mon should be in the dock. Your Lordship will remember that. And so I'm not talking about that. All I'm saying is that that is proof enough that the private prosecution was in place. So the question of whether they should be in the dock or not would not have arisen if the private prosecution had been concluded. So as a matter of fact, the private prosecution was proceeding. Was alive, yes. But what makes it worse, my Lord, is that in September, by the time Your Lordship gives the reasons, according to, not me, according to this other side, the situation was still the same. They say they don't know what's wrong with us when we're saying the situation as of March and then September was different. It was the same. So, well, if we take their word for it, then it means even at the time of the granting of the reasons, the prosecution, to borrow Your Lordship's phrase, was alive. So that should be the end of it. Because that's a misdirection of fact that obviously goes to the root of the case. R versus Zuma, Your Lordship knows all those cases. So that's the first thing. But let's just be generous, my Lord, and say the situation had changed. Even if the situation had changed, the crucial point is March. And my Lord, the confusion, and again, as I say, I sympathize both with the court and my learned friends because these things. The confusion is this. It is true that by the 20th of March, the other case, the case about Section 18, you remember, my Lord? Yes. Yes, that case had already been decided. As Your Lordship knows, it had been decided by the SCA, and I'm not sure if it was already decided by the CC, but let's assume that it was. But that's not the case that's important. The case that's important is the main case of the private prosecution. That case could only die, quote unquote, to use the metaphor, once the Constitutional Court had made a decision. And it's common cause that the Constitutional Court had not made a decision. So on Pillar 1A, it's the issue of Your Lordship would not have hesitated, and B is the issue of the misdirection of fact. I won't even address the third issue. The third issue is that the SCA, the part from the SCA that Your Lordship quoted was from the Section 18 application, so it's really not applicable here. But those first 2 points are sufficiently conclusive. So let's go to Pillar 2. Now, again, Pillar 2 is, if I'm correct, just on those things on Pillar 1, I don't have to deal with Pillar 2. But for what it's worth, Pillar 2 says that that Mr. Downer is facing a serious charge of disclosing or leaking information to Ms. Mohan, and so on and so on. And then Your Lordship says, firstly, Mr. Downer denied having disclosed Mr. Zuma's medical information to Ms. Mohan, and secondly, the issue pertaining the release of Mr. Zuma's medical information was thoroughly canvassed by Kun J. So those are the two legs. Well, the first leg, my lord, cannot stand for the simple reason that, of course, I mean, I've never seen, well, I have, but very few accused persons I just admit. So the mere fact that Mr. Downer denies is really neither here nor there. The point of the matter is, what are the objective facts? So if Mr. Masuku is here and he puts in an affidavit that, no, I'm not in Maritzburg, I don't...
I'm not wearing black robes.
Yeah, and I'm not wearing black robes. Yeah. It doesn't matter. He can put that in 100 affidavits, but the objective facts are that he's here. So what are the objective facts? The objective facts are that Mr. Downer, in his own version, and in the version given by Mr. Breitenbach, goes like this, and I'm paraphrasing, that Ms. Mon contacted Mr. Breitenbach, or rather, it's a crucial mistake that I'm making. Mr. Breitenbach contacted Ms. Mon, and then they had the discussions. I don't want to bore your lordship with the details. But the common cause, and that you'll find also in Judge Kuhn's judgment, common cause fact is that as at the time of the disclosure of the controversial letter with the medical information, the papers had not been filed in court. They were only filed on the following day, on the 10th of August. All this other stuff happened on Women's Day, on the 9th of August. And then, so the only thing at this stage, we assume there's not enough reason to prosecute Mr. Downer. The only thing we say, my lord, is this. Look at it contextually. Mr. Downer, his version is that he knew that there was a problem of leakage in the NPA. At some point in his affidavits, he says he even condemned it himself, right? 2, he had been accused of leaking information to Mr. Soul. He knew that. 3, he knew that the law prohibits that. And let's assume it's not him who gave the information to Ms. Mon. When he discovered that Mr. Breitenbach had done that, his duty, according to the code of the NPA, would have been to report that. And he failed to do so. So let's say that's the least thing we're accusing him of. That knowing all this, he breached his duty to report the transgression committed by somebody else. That, my lord, is sufficient for the purposes of recusal to say that this is not a person that, if he can do that, my lord, remember, one of the key qualities for a prosecutor is that a prosecutor must be able to say, if evidence comes which assists the accused, that prosecutor must tender it to the court. So Mr. Zuma must now believe that Mr. Downer, who was busy leaking documents and so on, when the trial comes, if he came across evidence that supports Mr. Zuma, he would tender it. I mean, that's just really asking for too much. So even if the least he has done is simply not to report, that is sufficient for the current application. But here's the thing, my lord, which is bigger than what I've just said. Your lordship's second ground, you'll remember, is that Justice Kuhn had dealt with this matter. Yes. And this deals, yes, fine, thank you. This point deals both with Pillar 2 and 3, so I'm killing two birds with one stone. Your lordship is...
So I'm not going to address Pillar 3 anymore.
Yes, I won't, I promise, my lord. At least not in this aspect, I'll brush through it. But your lordship is quite correct. Yes. In fact, the issue of leakage is leakage. Whether it's to Ms. Mon or Mr. Soul, yeah. Yes. From a prosecutor's point, so I'll oblige with your lordship's request. But then, my lord, just listen to this. Let's call it the res judicata point. Because what really your lordship was saying is that this matter has been decided by Kuhn, J. Not only that, it has gone to certain appeals, and therefore your lordship
And possibly to the highest court of the land.
Of the land, yes, yeah. Now, at face value, my lord, that's unanswerable. Because your lordship couldn't, sitting alone, say, no, the constitutional court was wrong to accept. But I'll show your lordship that is not the case. Your lordship goes to page 13 of the bundle.
That's your bundle, isn't it?
Of our bundle, yes, my lord. You'll see, my lord, that Kun J disavows any notion that he decided these matters decisively. Let me read it out, then I'll explain, my lord. At the top, paragraph 15, my lord. My lord, if your lordship can excuse me, can you start on the previous page? Yes, just at the
That's
bottom.
12.
12, yes. Just at the bottom, just to give it context. He said, yeah, I, however, found that if I was wrong and what was properly before me was an application for the removal of Mr. Downer, and or that the wide meaning of the phrase title to prosecute contended for by Mr. Zuma was the correct interpretation of section 106, that the 14 grounds, that's where the important part, the 14 grounds were nevertheless without substance and had to fail. Now we know one of those 14 grounds was this issue of the leakage. And to follow your lordship's advice, two of these, it was the leakage to Mr. Soul and the other one to Ms. Mon. So again, we deal with pillars 2 and 3 in the same breath here. Now, he says, in reaching that conclusion, I rejected these grounds, which is true, in many instances on the facts, and made findings and expressed certain, even strong views, which is what your lordship said. And he says, the collective impact of my comments in the aforesaid respect should also not be ignored. Here's the important part. The refusal of the various applications for leave to appeal by higher courts as not having prospects of success could be based, especially as I believe that to be the correct application of the law, on the narrower interpretation of the word title to prosecute. If that is so, then the dismissal of the appeals would not have involved a tacit approval of my views and conclusion on the 14 grounds of complaint, which were dismissed as without substance in the alternative. Your Lordship, yes. So what is Justice Kuhn saying, my Lord? He's saying, don't read too much on the fact that I rejected Mr. Downer's participation. Don't even read anything on the fact that the higher courts have found, because those higher courts may well have rejected the appeal simply on the basis that the meaning of the word title to prosecute is narrow. There was a whole debate about that, which I don't need to bore your lordship with. And not on these issues of the 14 grounds. In other words, the question as to whether Mr. Downer was liable for the leakages to Mr. Soul and Ms. Mon is an open question still on what Justice Kuhn himself says. And we know that he says elsewhere, which I read earlier, those are issues to be determined at the trial. So the state, in this case, reliance, your lordship with respect, the reliance on Judge Kuhn's remarks is inappropriate, because Justice Kuhn himself says that his findings should not be relied on because the jury is still out on them.
Just one minute, please.
Thank you, my lord.
Or should we perhaps say that the court's reliance on the remarks that were made by Kun J is misplaced.
As God pleases, my lord. As God pleases. I wouldn't be able to place it that strongly myself.
I know.
Out of respect. My lord, your lordship, well, that reliance that your lordship is talking about is undeniable, because your lordship goes on to say at paragraph 5 of your judgment, Kun J found as an undisputed fact that Mr. Downer made no such disclosure to Ms. Moan. A similar finding was arrived at by the full court of this division. This finding was again confirmed by SCA. It is important to note that every attempt to overturn Kun J's judgment had been unsuccessful. Findings made in the removal and private prosecution judgments are binding to this court. So, with the greatest respect, without even arguing the nuances as to whether one can apply the private prosecution judgment and so on, it's misplaced, quote unquote, at the minimal level, in the sense that the success or unsuccessfulness of Kun J's judgments is, as explained by himself, irrelevant. So I have to keep to my promise that Pillar 3 goes with Pillar 2, subject. Goes hand in hand, at least as far as the application for leave to appeal is concerned. Subject to your lordship just giving me one leeway, and it is this, and I'll paraphrase, I won't even go to the papers. The leakage to Mr. Soul, my lord, is quite frankly in a league of its own. Because here, again, it's no use to say Mr. Downer denies it, because again, as with the example with Mr. Masubu, it doesn't matter what Mr. Downer says. We have a transcript of the discussions. So he can deny, but unless if he says that transcript has been doctored, the transcript is the transcript. So, on its own merits, my lord, remember that transcript comes from the so-called spy tapes. It's not some information that was volunteered by the NPA. It came from the spy tapes. Turns out in the spy tapes that Mr. Downer had 8 conversations with Mr. Soul about this case. And in certain places, even advised him on how to write his article. Now, again, one doesn't have to be a lawyer to know that that's wrong. A prosecutor can't do that. The contents of those discussions, my lord, is, to say the least, distasteful. Because, and this is not even half of it, it's just what you call a tip of the iceberg. Sorry, my lord. And your lordship must consider this against the background that Mr. Downer's defense is that he was not discussing Mr. Zuma's case. I mean, that's just ridiculous. Which case was he discussing when he says the following? Everyone knows about the mutual legal assistance application. They are sitting on it and haven't done anything. In respect of that process, DOJ has done F-all, a four-letter word. Mr. Soul says, but I know I don't want to get you into another four-letter word. Can we say German investigations reopened? Can't be opened because it was never closed. Your lordship will find that at paragraph 117. Yes. And then here are the 2 ones that Mr. Downer says, in respect of the Germans, the terms of our 2001 declaration of investigation include the whole of it not to be declared ongoing since 2001. But you can't quote me to say that. In other words, don't reveal my name. Sam Soul, no, I'm not going to quote you at all. Here's the one that takes the cake. Where he actually tells Mr. Soul how to write his article. Says, Mr. Soul says, there has been a formal request for a joint investigation. That's Mr. Soul. Mr. Downer says, yeah, But just avoid the term joint investigation when you write the article, because the minister hated it. That implies that we let them investigate our offenses. What you want to use is the term parallel investigation. So he's actually telling him how to write the article. So unsurprisingly, Mr. Soul would have written it as suggested by Mr. Down. And I just want to leave that there, my lord, just to keep my promise to you. Just to say this one is even of a higher degree. In which universe, and the list is the best one. Mr. Downer says, well, I only mentioned Mr. Zuma once in those conversations. How many times must he mention him for us to know that he was discussing Mr. Zuma's case? And the rhetorical question, my lord, is that in which universe can Mr. Zuma sit as an accused person being prosecuted by somebody like this who was basically writing articles about how his case should be handled? The answer to that is self-evident. Then, my lord, that then takes us to Pillar 4, which Mr. Masuku is going to deal with. But let me just round off like this, my lord. Let's assume, for argument's sake, let's just take the two pillars that your lordship asked me to put together. Assume there was no other Pillar 1 or Pillar 4. That, my lord, is an illustration of the point we make about the cumulative effect. In other words, let's assume the leakage to Ms. Mon on its own was insufficient. And let's assume again, wrongly, that the leakage to Mr. Soul on its own was insufficient. But viewed together, my lord, surely they show a pattern of these leakages involving Mr. Downer. And on that cumulative effect of just of those two, forget Glenister, forget all these other things, the issue of another court would come to the reasonable conclusion that there is sufficient smoke to avoid this. And the lordship, well, this is both a citation of authority, but it's also a criticism of your lordship. That your lordship, one of the most glaring things about this case is that your lordship failed with respect to deal with the case of Smythe, S-M-Y-T-H, versus Usheogunze, which both Justice Kuhn relies on, and it has been relied on by our Constitutional Court many, many times. And that, your lordship, will find at page 33 of our bundle. And again, to save time, I'll simply just gloss over the importance of that case. That case, my lord, is clear authority. You cannot decide an application of this kind without dealing with that case, I'm afraid. Because that case is clear authority for two crucial propositions. One, that prosecutorial independence is an integral part of the Section 34 rights of an accused person.
Just a moment, please.
Yes.
Yes.
I'm even putting aside Section 35, my lord, now.
Yes.
I'm saying just the pure Section 34 rights of an accused person to an impartial court. And what the judgment says, my lord, is that the concept of an impartial court cannot be confined to judges, because that would be a restrictive interpretation of the Constitution. The concept of an impartial court surely includes the prosecutor, because the accused person or every citizen is entitled to an impartial court. That's the first thing that Smythe says. But Smythe also says, my lord, that it makes the point that we made earlier, that society is an important consideration. Society cannot just be watching this kind of thing where a prosecutor who clearly has taken sides is prosecuting a person. And it comes to that word I said Your Lordship should underline, detachment. Because the sole question is this prosecutor sufficiently detached from this case? That's really the issue. And Your Lordship will find at page 36 of the bundle, this is what the court said in Smythe. There are no paragraphs those days here. It says, it is specifically alleged that the first respondent, or rather against the first respondent, that he has involved himself in a personal crusade against the applicant. Let's put that aside. And very important, and that he lacks the objectivity, detachment, and impartiality necessary to ensure that the state's case is presented fairly. So that was the case. And then let's jump to page 1134, which you'll find at page 37. And this is the point I made earlier. Remember, in Zimbabwe, the equivalent of our section 34 was section 18.2. So whenever it says 18.2, just think section 34. It says, I have no difficulty in acknowledging the inherent danger of unfairness to the applicant attendant upon the first respondent prosecuting at the trial. Hence, the question that arises is whether the applicant's right to a fair hearing by an independent and impartial court established by law as enshrined in section 18.2, that is our section 34, of the Constitution, is likely to be contravened. To put the inquiry more pertinently, whether the words, quote, impartial court are to be construed as to embrace a requirement that the prosecution exhibits fairness and impartiality in its treatment of the person charged with a criminal offense. In arriving at the proper meaning of the content of the right by section 34, it must not be overlooked that it is a right designed to secure a protection and that the endeavor of the court should always be to expand the reach of a fundamental right rather than to attenuate its meaning and content. What is to be accorded is a generous and purposive interpretation with an eye to the spirit as well as the letter of the provision, one that takes full account of the changing conditions, social norms, and values, so that the provisions remain flexible enough to keep pace and meet newly emerging problems and challenges. The aim must be to move away from formalism and make human rights provisions a practical reality to the people. And then it says, my Lord, that section must be interpreted, therefore, in a broad and creative manner so that to include within its scope and ambit not only the impartiality of the decision-making body, but the absolute impartiality of the prosecutor himself, whose function as an officer of the court forms an indispensable part of the judicial process. His conduct must of necessity reflect on the impartiality or otherwise of the court. And then it goes on. The next paragraph is also relevant. I just won't read it out to save time. So Smythe, my Lord, is pertinent and it answers the question. With your Lordship's permission, may I just come back to one aspect that I left out when I was dealing with the issue of reasonable apprehension. My Lord, your Lordship would have noticed that our learned friends' retort to the point about reasonable apprehension of harm is Porritt. So they rely on the case of Porritt. They say that the case of Porritt is authority for the absurd proposition that reasonable apprehension of harm is not to be applied to prosecutors. Well, my Lord, that's palpable nonsense, because Porritt is not authority for that proposition at all. What Porritt says, which we concede, is that the recusal of a judge and the recusal of a prosecutor are not to be equated literally. But the standard of fairness is the same. Fairness is fairness. Impartiality is impartiality. But obviously, courts are rather, judges must be judged by a higher standard. That is not to say that prosecutors must not be judged by any standard. It's simply to say that you don't apply, for example, the double reasonableness case, the so-called, actually it might even work against a prosecutor, because against a judge you have the presumption of impartiality, which the prosecutor doesn't enjoy. But that's not even what I'm making. The point I'm making is that it's just simply not true to say Porrit is... because after discussing what I've just said, my lord, this is what the SCA said in Porrit at paragraph 17. And your lordship will find that at page 5 of our bundle. Thank you, my lord. So if your lordship starts at page 4, not now, if your lordship starts at page 4, you'll see the discussion about the differences between the judges and SARFU and all that. Yes. But this is what the court then says at paragraph 17. But this, in other words, that discussion, does not mean, I mean, how clear must it be? But this does not mean that a prosecutor can never be disqualified on grounds of bias or apprehension of bias. Where his or her bias affects the accused's right to a fair trial, a prosecutor may well be disqualified. In Smythe versus Usheokunze, then it goes into the facts of that case and so on. So here in black and white, the SCA says that when it comes to prosecutors, you can use bias and apprehension of bias. So to come to this court and say that the Porrit case is authority for the proposition that reasonable apprehension of bias is not applicable to prosecutors is, if it's not misleading the court, at least it's wrong. I don't want to attribute anything further than that. It's simply wrong. That case is not authority for such an absurd proposition. My Lord, those are our submissions. And if, in closing, my Lord, I would like to simply say, in addition to what Mr. Masuku is going to say, that remind the court where we started this morning. All this I've said, my Lord, is not for the purposes of asking your Lordship to change your judgment. You can't. Even if you wanted to, you're not allowed to do that. Your Lordship is simply being persuaded, hopefully, that on all these considerations, there's a reasonable possibility that another court would come to a different conclusion. Because these are not trivial matters, my Lord. A person's liberty is at stake. This is a criminal matter. These things would be important even if it was just something about a traffic offense. But no, this is a matter where we are saying that you must subject an accused person to a lengthy prosecution at the hands of a person who is undoubtedly tainted subjectively and objectively, actually and perceptively, whichever way you want to look at it. And the question we've always asked, which is supposed to be rhetorical, is why does the NPA insist on one person? Because this trial would have long started if they had accepted that there's no person who's indispensable in these cases. When this case started, it was run by our learned friend J. Kemp, who's no longer with us. And the client had to find other persons to do it. Similarly, if Mr. Downer, for good reasons, constitutional reasons, is disqualified, it does not mean that the matter... That is the end of the case. My Lord? It doesn't mean that is the end of the case. Absolutely. It doesn't at all, my Lord. And it's no answer to say there'll be practical considerations or financial considerations. Since when do practical considerations trump the Constitution? Because if there are constitutional reasons for his removal, that's it. We've seen that in the Meiwa trial, which is a public matter, where a trial of such importance had gone to so many lengths. But when the judge had to be changed, unfortunately, the law says you have to start de novo. It was not nice for anybody, but so be it. You can't say, well, that's the end of the road simply because a particular individual is unable to run that particular case. As the court pleases, my lord. We're indebted to your lordship.
Yes, thank you. Can we, Mr. Masuku, take a comfort break, 15 minutes comfort break before you start your argument?
Yes, court.
Stand adjourned for 15 minutes.
One two one two one two one two one two. Hello 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 hello. 1 2 1 2 1 2 3 4 1 2 3 4 1 2 3 4 1 2 3 4 1 2 1 2 1 1 1 1 1 1 1 1 1. Right. Yeah.
know that his investigative role is spoken to in the heads of argument. The reference is made to the remarks made about his role in the Sheikh case. But we have not seen in the affidavit of Mr. Downer any specific descriptions of exactly of what role he played as an investigator. Because you'll understand, my lord, that details of his involvement in the investigation are important in this matter. And no one should not have to second guess what role as an investigator Mr. Downer played. They are important, the details of his involvement as an investigator are important because of what has transpired from the mouth of the NPA itself about the thuggery and the criminality that followed the investigation of Mr. Zuma's prosecution. One has to go no further than look at the affidavit filed by the NPA itself, deposed to by Mr. Hofmeyer, in which acts after acts of misconduct, both in the investigation and the prosecution, are set out in detail. Of course, there's no mention of Mr. Downer as having been involved in any prosecutorial misconduct in those affidavits. But what is clear there is that where there are allegations that there's been prosecutorial acts of misconduct coming from the NPA itself, it's important that Mr. Downer explains exactly what role he played as an investigator, not as a prosecutor. So you'll not find anywhere where Mr. Downer says, well, this is what I did, this is the investigation I conducted, it was innocuous, it had something to do with A, B, C, and D, and that's it. So the fact that he doesn't say anything about his investigative role, in the context of the complaints that are raised in this particular case, not just by Mr. Zuma, but by the NPA itself. The NPA itself, where he deposed an affidavit, of course, suggesting extricating himself from what was in that affidavit. But he does not point out exactly what, as an investigator, he did. Now, from what Mr. Mpofu has said about Mr. Downer's other activities outside, speaking to the media and speaking to, particularly Mr. Semsol, where he specifically coaches Mr. Semsol on how to report on an issue related to this particular case. It's important what Mr. Downer did as an investigator. Now, we know that the allegations that are contained in the NPA's own affidavit, setting out in detail what was wrong with the investigation, what was wrong about this case that resulted in Mr. Mshe terminating the prosecution. No inquiry was ever done. In other words, we don't have an NPA saying, we did an inquiry about this affidavit, and this is the circumstances in which it came out. And the facts that are set out in that affidavit are completely wrong. As we stand, those facts stand as they are in that affidavit. Mr. Downer tries to extricate himself from those facts, but he cannot do that, obviously, because he didn't write the affidavit in the first place, but because that evidence is evidence that is clearly accepted by the NPA as impugning the investigative role of the Zuma matter. So the Glenster principle, as we see it, is the principle that you've got to keep the separation of prosecuting and investigation separate. But where there's an overlap, it has to be done lawfully. Now, even in the overlap where Mr. Downer fits in, he says nothing about his investigative role. And what precisely he did in this particular case of Mr. Zuma as an investigator.
Just a moment, please.
Where he fits... Sorry.
Just a moment, please, Mr. Nasser. Yes, Mr. Nasser.
Exactly where he fits in the picture painted by the NPA itself when they make the allegations of investigative misconduct relating to this particular case. Now, there is a debate between the state and ourselves on the true import of the true meaning of the judgment of Glenister. The furthest I want to take that debate is simply to refer to Your Lordship to paragraph 66 of that particular case, the Glenister judgment, where it says that it is apparent from the record and that was the record that was before the Constitutional Court at the time, that that the decision was one of policy, and that was the decision to change, to move the to establish the DSO as a policy decision. It says that the decision was one of policy, fine, supporting the record. The memorandum on the objectives for amending the impugned laws set out a number of reasons for the disbandment of the DSO and establishment of the DPCI. In this regard, the Khampempe Report Commission was appointed in order to look into issues such as the lack of coordination between DSO and SAPS, the lack of oversight over the DSO, and the operations conducted by DSO outside its mandate. The memorandum also highlights the need to address organized crime in a more comprehensive fashion. It is apparent from the record before us that the establishment of the DPCI and the disbandment of the DSO stemmed from, among other concerns, the controversy that surrounded the DSO since its inception. In particular, concerns about the level of involvement by the prosecutors into investigations and the loss of objectivity of prosecutors leading investigation. Now, this concern which was raised is also recorded by the Constitutional Court on page 35 of the judgment, footnote 57, where the court says it bears mention that there was some concern that the DSO under the NPA was perhaps too independent, operating as a law unto itself. The point here is this: is it good prosecutorial policy to appoint as a prosecutor a man or a prosecutor who's been involved in this kind of prosecutorial or investigative controversy, in which he does not point out why the controversies around the investigations do not implicate him too? He says nothing about it. But we know that Mr. Downer was quite actively involved in driving the narrative of how this case should be driven. So that is really the Glenister point. The Glenister point is, Your Lordship, if you had considered that point, it would have resulted in a situation where you would have said, well, there is a separation of functions between the prosecutor and an investigator and prosecutor. You played both. You played for both teams, investigators and prosecutors. But you don't tell us exactly what you did when you were an investigator. But we know that in the investigation, there is a full affidavit by the NPA pointing out serious transgressions that occurred, unlawful conduct that was committed during the course of the investigation. And Mr. Downer says nothing about that. But that's too is of concern, because when one looks at how Mr. Downer has treated the NPA's own evidence on investigative misconducts and the reference to the Hofmeyr affidavit, you'll see that in his answering affidavit in the main application, he refers to he's got an annexure, or it attaches an annexure of what he calls Mr. Zuma's Stalingrad, examples of Mr. Zuma's Stalingrad approaches. And we point out in there, my lord, that he omits critical issues that relate to the misconduct that was committed by the NPA when they conducted this investigation. So he blames Mr. Zuma, but a number of things. This is what he did. For 20 years, he says, Mr. Zuma was involved in delaying this trial, adopting all sorts of strategies, including a permanent stay he brought. That is part of a Stalingrad. not a legitimate exercise of his fair trial rights. They condemn everything he has done, and they lump it into 20 years, and they say, well, he committed, he was engaged in a destructive path in which he was avoiding to be prosecuted. A prosecutor who starts labeling with untruths, because what he says there is untrue, in the sense that it doesn't specifically mention specific events relating to prosecutorial misconduct or that implicate prosecutorial misconduct of the nature that should be deprecated involving the investigation of Mr. Zuma's case. It doesn't mention them at all. He condemns Mr. Zuma as a Stalingrad expert who launches application over and over again only to fail. Now that on its own doesn't recognize the dignity that Mr. Zuma has. And with respect, we would say the reason why Mr. Downer has taken this very spirited commitment to prosecuting this case is simple. It's because he was involved in the investigation, and as a result of his involvement in the investigation, he has lost perspective.
Just a moment, please. Yes.
This has become, because of what he knows as an investigator, it has created this sense of indispensability. And it doesn't matter how much the NPA says. We ourselves looked at this case. We know that there were investigations that were not conducted in accordance with the law, that there were criminal acts that were committed while these investigations were taking place. Mr. Downer, as we put it in our affidavits previously, tries to sanitize that conduct and presents himself as somebody who is capable of still presenting a fair, impartial prosecution on the case. With respect, it's not possible for Mr. Downer to be completely detached, as the Shokunze would require of a prosecutor, to be detached from what he has seen, where he has been, what he knows about the case. He's become so committed. And it's important, Your Lordship, that this point is understood from the point of view of what is required for a fair trial of Mr. Zuma or any accused person. When Mr. Zuma says, bring any other prosecutor, what is the response from them? The response is no, it's indispensable. We want to choose a prosecutor for the NPA. But that's not the point. The context in which that practical position is raised, the practical position is the requirement that in Section 35(3), that an accused person is a right to have a trial begin and end quickly. So if Mr. Downer is now mired in this controversy, which has dominated for the past 4 or 5 years, no, in fact for more than 5 years, why is it not practical for the NPA to simply appoint somebody else to come and do the prosecution and conduct the prosecution? The only reason why he stands today as the only prosecutor who can prosecute this case is because of his many roles that he played, one of which is that he was an investigator in the case. And we say that if Your Lordship had dealt with the issue of Glenister, you would have appreciated the fair trial complaints that Mr. Zuma was raising when he was saying Mr. Downer's appointment was done in violation of that particular principle, which recognizes the distinction between an investigative role and a prosecution role. And that even when you conflate them or when there's an overlap, that overlap cannot destroy the conceptual distinctions that exist in that particular in the act. But here is another point that arises from how the state has dealt with the issue of why we are raising these complaints and why we want Mr. Downer not to prosecute this case. And of course, other than accusing us of engaging in an attempt to subvert lawful prosecution by engaging in Stalingrad, they fail to understand that the Constitutional Court itself in S versus Shabir Sheikh, a judgment which is referred to by my learned friends in their heads of arguments, and you'll see, Your Lordship, the citation is right at the bottom in the table of contents. In paragraph 38 of that judgment, the judgment makes it clear that any complaint of unfair trial must be made timelessly, in particular before the High Court and the Supreme Court of Appeal. That's what section paragraph 38 says. A complaint of unfair trial must be made timelessly, in particular before the High Court or the Supreme Court of Appeal. So what we're asking Your Lordship to do is to allow us to raise these complaints of unfair trial in the Supreme Court of Appeal. And you'll see from paragraph 39 going further in that particular judgment, my Lord, that a great deal of time is committed by the Constitutional Court to look at when it is appropriate for a party to raise prosecutorial misconduct. And this is the point that the state misses, that where there are complaints about prosecutorial misconduct, you don't wait until there's a conviction, because the existence of prosecutorial misconduct or the possibility of the existence of prosecutorial misconduct is destructive of fair trial rights. It exposes the accused to unfair trial, but not only that, it just undermines the public confidence in the criminal justice system. And for public confidence, it is important that the issue relating to whether a prosecutor's involvement in the prosecution will promote a fair trial is actually adjudicated before the conviction of the accused person. And that you'll find, as I say, my Lord, in the Sheikh judgment, it's discussed extensively from paragraph 38, 39, you'll see it in paragraph 40, 51 up to 68. All those paragraphs are paragraphs in which the Constitutional Court went meticulously dealing with why Mr. Sheikh could not succeed, for example, in his allegation of prosecutorial misconduct. Because the Constitutional Court said no, because you didn't raise them in the High Court. If you didn't raise them in the High Court, why are you raising them now? You only raise them because you have now been convicted. And that is the reason why it's important that your Lordship gives us the opportunity to have this matter ventilated further in the Supreme Court of Appeal. My Lord, perhaps let me just deal with this issue of Mr. Downer's designation as a prosecutor. I just deal with it for emphasis. You'll find that in BT1, on page 623 of the record, the first designation was that of McCarthy.
Sorry, what page again?
Page 623.
Is that the founding
It's BT1.
Is that the answer?
That's the answering affidavit. That's Mr. Downer himself attached the designations.
Okay.
And you'll see on page 624, it says, I hereby, in terms of section 28(2)(a) of the Act, designate Advocate William John Downer to conduct the investigation on my behalf and to report to me. And that's by McCarthy. Now, if you look at what McCarthy is accused of in the affidavit of fourth mayor, and I'm afraid the affidavit of fourth mayor is not going away. That affidavit tells a gory story of how a legal system can simply be subverted by a functionary like Mr. McCarthy. And here is Mr. McCarthy saying to Mr. Downer, please investigate. Mr. Downer doesn't tell us exactly what he did as an investigator. You'll see in PT2 that he was also asked to conduct an investigation. That's page 625 of the record, and it was also by McCarthy. He must conduct the investigation on my behalf and report to me. And then you will see on page 627. Oh yeah, in fact, let me point out on page 625, you'll see that Mr. McCarthy says, whereas I've decided to hold an investigation in terms of section 28(1)(a) of the Act regarding specified offences as intended by the Act, namely the offences of fraud and corruption in contravention of the Corruption Act that have been committed or are being committed, or in respect of which an attempt has been made to commit such offences arising out of the armament acquisition for the Department of Defense. And whereas I decided to extend the investigation to include the following offences, the suspected commission of offences of fraud and corruption in contravention to Corruption Act or the attempted commission of these offences arising out of payments to or on behalf of and for the benefit of Jacob Zuma by Shapia Sheikh. And then you'll see the second one, the protection of and the wielding of influence and using public office to unduly benefit the private business interests of Shapia Sheikh and of Nkobi Group of companies by Jacob Zuma. So he was clearly involved on the authority of Mr. McCarthy in conducting an investigation of this particular case. Now, if you take that, his involvement, and then you look at what the NPA says about the criminal activities that were involved in the investigation of Mr. Zuma, you have to ask the question, is this the prosecutor that is appropriate for this case? Because he cannot extricate himself from the allegations made by the NPA on how crime was committed in trying to secure evidence against Mr. Zuma. My Lord, that affidavit of Mr. Hofmeyer is so important in this case, it's not going anywhere. And Mr. Downer will conduct this trial if he's allowed to conduct it. That affidavit and what the NPA said will always be on his face. Let's put it that way. It will be there, right there on his face. And you'll have to deal with the fact that his own organization, which asked him to go and investigate, is coming back and saying, when this investigation was done, we have done our investigation about the quality and the lawfulness of this investigation. We've come to the conclusion that these investigations were done unlawfully. There was a lot of stuff that happened there which was not in accordance with the law. And you'll see that the last designation that he attaches is the designation by Mr. Mgwengwe, Advocate Mgwengwe. And there, Mr. Downer was the lead investigator. That's page 628. And you'll see that he was assisted by Anton Leonard John Steinbeck, George Baloy Msweli, but he was number one. Now, and of course, soon after that, in 2005, sorry, it was before Mr. Zuma was charged in June 2005. No, it's after. Yeah. So we say, appreciating this distinction between a prosecutor who has been involved in an investigation, who plays a role that fits within what the Constitutional Court in S versus Sheikh says, there's no controversy about that involvement. For example, he explained his role in the Mauritian investigation. He explains, he says, no, I did this and that and that. I stood there and I watched the people to conduct this investigation. I didn't get involved in any other way. You will find no way where he tells you how he went about investigating Mr. Zuma as in the second designation of BD2, where he was asked to investigate the payments that were allegedly made corruptly by Mr. Sheikh to Mr. Zuma. Then my Lord, the issue that I think is very important for this application for leave to appeal. It's an unpleasant thing to say. But if you look at BD4 from page 629, and you read it together with what he said in his affidavit, when he condemns Mr. Zuma as engaging in Stalingrad tactics, remembering how courts have characterized the Stalingrad approach. They don't like it. They regard it as a tactic for people who are well resourced. In fact, in their heads of arguments, they tell us exactly why courts don't like the Stalingrad. Now, a prosecutor goes to court and says, Mr. Zuma is involved in a Stalingrad approach because he has brought an application for leave to, an application for permanent stay. He has brought an application challenging the encrypted facts. He has brought an application to do this. All of it is listed in BD4 as forming part and parcel of Stalingrad. But what takes the cake for us is that the 20-year delay, Mr. Downer says Mr. Zuma is involved in it. And that's a blatant lie. No, I put it no further than that. It's a blatant lie that Mr. Zuma, if you look at the facts dispassionately, was involved in 20 years of avoiding his prosecution. He doesn't mention the fact that Msimang, just the late Justice Msimang, struck the matter from the role because Mr. Downer couldn't conduct the prosecution at the time. He doesn't say that. He doesn't mention the fact that the NPA filed an affidavit in which they condemned their own investigation. And they said our investigation was unlawful, we're involved in thuggery, we're involved in criminality, we involved foreign spies. They even mentioned those spies as CIA, and they mentioned the names of those people. Mr. Downer doesn't mention this as part and parcel of the problems that arise from his side of the story. In other words, he doesn't present a fair picture of what has gone wrong with this particular case. He is passionate about presenting Mr. Zuma as engaging in a Stalingrad tactics. In the eyes of the courts, which have in a series of judgments, condemned people who engage in Stalingrad approach, that can't be right. You cannot consider that to be a prosecutor who is dispassionate, who is involved in a case where the main event is not winning. The main event is really to present the evidence for the courts to determine whether the person is guilty or not. Of course, to try and secure a conviction if he can. But that's not the main objective of prosecution. That, I think, is a well-known principle. So I would say, with respect, my Lord, when one looks at the requirements of a fair trial, and the allegation is that there was prosecutorial misconduct, and that the prosecutor's misconduct is implied, or rather is implicated in this acts of prosecutorial misconduct, those are issues to be raised right up front. To condemn that as acts of Stalingrad is irresponsible. Is to scandalize an accused person, and is demonstrative of the fact that this particular prosecutor is no longer fit to conduct a trial in accordance with the principles of our Constitution. So we would say with respect, adding to what Mr. Mpofu eloquently pointed out, in his address to your Lordship, we don't seek Mr. Downer's removal out of fun. It's not a sport. We're not engaged in a sport. We're engaged in the exercise of constitutional rights. And we say Mr. Downer is not indispensable. And the NPA would be wise to remember that this spirited opposition to Mr. Zuma's application has delayed the start of this trial. In circumstances where it doesn't say we don't have the resources to find another prosecutor, we don't have ways of getting this trial moving. We've said to them, give us another prosecutor, we'll run the trial. They've insisted on Mr. Downer. But the result of that is that Mr. Zuma gets prejudiced with further delays in his prosecution. So we would say that the indispensability of Mr. Downer raised within the context of fair trial rights ought to have been considered differently, because the duty of the prosecution is to demonstrate that they're able to start the trial and end it expeditiously. Mr. Downer right now can't say to the courts, I will start the trial and end it expeditiously, because he's mired in the controversy of prosecutorial acts of misconduct and investigative misconducts. So in the circumstances, we would say, together with what Mr. Mpofu has said, that leave to appeal should be granted on the point of the Glenstar rule, if one puts it that way, and the indispensability rule. Mainly because Mr. Downer, because the court did not deal with the sorry, not Mr. Downer, mainly because the court did not deal with that particular aspect. The Supreme Court of Appeal may well appreciate the importance of that distinction between a prosecuting role and an investigative role. And where Mr. Downer has been accused of being involved in the controversy that we now see, whether or not that distinction went beyond what would be considered a lawful investigative and prosecutorial roles playing together against one man, Mr. Zuma. So we would ask that the court grants leave to appeal to the Supreme Court of Appeal.
Thank you.
As the court pleases. Thank you.
Mr. Reichenbach?
Do you mind if I give you the...
Sorry.
Just move it more towards this. Don't come close to Mr. Mpofu.
Just a bit worried about the wires here.
Yes.
Thank you. My Lord, the state opposes this application. And we have 4 main contentions, which I shall address in the oral argument today. In the first instance, the state contends that Mr. Zuma doesn't have a right to seek leave to appeal at this stage of the criminal proceedings because Section 316(1) of the Criminal Procedure Act, read with Section 315(2) thereof, being the very provisions on which he brought the application for leave to appeal, do not permit an accused person to appeal before they have been convicted and sentenced. Obviously, if that happens at all. So the first ground is located inside the Criminal Procedure Act and the provisions on which the application is brought and which we contend are the applicable ones. In the alternative, and assuming that somehow Chapter 5 of the Superior Courts Act is applicable, we submit that permitting an appeal at this stage will be contrary to Section 17(1)(c) of the Superior Courts Act, because the appeal will not lead to a just and prompt resolution of the real issues between the parties. Thirdly, and irrespective of whether the appeal is governed by Sections 315 and 16 of the Criminal Procedure Act or Chapter 5 of the Superior Courts Act, we submit that permitting an appeal at this stage of the criminal trial will not be in the interests of justice. And there are essentially 2 reasons for that. There is no reasonable basis for the contention that Mr. Zuma will suffer grave injustice if his criminal trial proceeds with Mr. Downer as a prosecutor. And the second is that the intended appeal is a continuation of Mr. Zuma's Stalingrad litigation strategy, which has as its aim delaying the criminal proceedings and, if possible, avoiding a trial on the merits of the charges against him altogether. Fourthly, we submit that permitting an appeal would be contrary to the rules governing appeals, which essentially require that the intended grounds of appeal have reasonable prospects of success. And we also submit there is no other compelling reason, those being the words of the relevant part of section 17(1)(a), why the appeal should be heard at this stage as an intermediate appeal. I would like to start then with our submissions in relation to section 316 of the Criminal Procedure Act. As I indicated, in his first notice of application for leave to appeal, Mr. Zuma stated that he brings the application in terms of section 316, read with 315(2) of the Criminal Procedure Act. Your Lordship will find that if you have the little bundle of authorities, the bundle of the proceedings relating to this particular application at page 3. There is a notice of application for leave to appeal in terms of those provisions. Sorry, it's not the bundle of authorities, it's the smaller one at page 3. In the tram lines, the document is styled notice of application for leave to appeal in terms of those two provisions. Now, section 316, sub 1, reads, and I leave aside the opening portion which is not relevant, any accused convicted of an offence by a high court may apply to that court for leave to appeal against such conviction or against any resultant sentence or order. The latter order obviously being an order of forfeiture, for instance, under section 300 of the Criminal Procedure Act, or indeed under the Prevention of Organised Crime Act. But the jurisdictional fact is any accused convicted of any offence by a high court. Now, in Justice Kuhn's judgment of the 16th of February 22, dismissing Mr. Zuma's application for leave to appeal against the dismissal of Mr. Zuma's first attempt to have Mr. Downer removed as the prosecutor, that is in case number 24 in the authorities bundle, he held that section 316(1)(a) of the Criminal Procedure Act precluded Mr. Zuma from appealing before conviction, and in that instance it would be against the dismissal of his special plea. And the relevant paragraphs are 64, 73, and 77. And I'll read just a portion of one of them. His Lordship said, the provisions of section 316(1)(a), thus construed in its context, include decisions made during a criminal trial, and they may be appealed, but only after conviction. Hence, no appeal against any decision, including the dismissal of a special plea in terms of section 106(1)(h) of the Criminal Procedure Act, would generally, on the aforesaid interpretation, be possible prior to conviction, and for good reason, namely to prevent the piecemeal disposal of criminal trials. Now, it is so that there are many, many decisions which have to be made in the course of criminal trials, well before the court delivers its judgment on the question of guilt or innocence. And His Lordship's finding with respect is binding on this court is that there is no such appeal under Section 316. If Mr. Zuma's application is taken at face value, an application in terms of these provisions, it is premature and must be dismissed for that reason alone. And your Lordship need not enter into any of the other issues or questions raised in this matter, because it is an application in terms of a provision which only allows it to be made in the future, and then only if Mr. Zuma is convicted. The intended appeal will be entirely unnecessary if Mr. Zuma is acquitted. On the assumption that the submissions that I have just made are not well founded, the question then becomes, well, what is the legal basis, authority for this application which is before the court today? And there are indications in the papers, including in our learned friends' heads, that they approach this matter under Chapter 5 of the Superior Courts Act. Now, as you know, the state's position is that that chapter is not applicable because in Section 1 of the Superior Courts Act, the term appeal is defined as follows. Appeal in Chapter 5 does not include an appeal in a matter regulated in terms of the Criminal Procedure Act or in terms of any other criminal procedure law. And this application being brought in terms of the detailed procedure, purportedly in terms of the detailed procedure in Section 316, is consequently an appeal which is not included in Chapter 5. But assuming we are wrong about that, and we are in Chapter 5, then the governing provision is Section 17(1), which, as the court knows, provides in its relevant part, leave to appeal may only be given where the judge concerned is of the opinion that the appeal would have a reasonable prospect of success, or there is some other compelling reason why the appeal should be heard, and C, I've just read to you A, or the relevant portion of it, where the decision sought to be appealed doesn't dispose of all the issues in the case, the appeal would lead to a just and prompt resolution of the real issues between the parties. And again, in His Lordship Mr. Justice Kuhn's judgment of the 16th of February 2022, to which I've referred, this time at paragraph 78, His Lordship deals with the implications of this provision for an intermediate stage or piecemeal appeal such as the one which is contemplated here. There, in relation to the Section 106(1)(h) intended appeal, His Lordship said, an appeal against the dismissal of the special plea, if successful, would not lead to a just and prompt resolution of the real issues between the parties before the court. In this instance, Mr. Zuma's guilt or innocence. In the absence of a prompt resolution of that real issue between the parties, there is no scope for an appeal prior to conviction based on Section 17(1)(c). And we submit that that finding applies with equal force to the present intended appeal. So that is a statutory bar to an appeal like this, because its outcome will have no bearing on Mr. Zuma's guilt or innocence of the charges in the main case. It is, however, contended that an appeal at this stage would be in the interests of justice. And we accept, on the authority of the cases cited in our heads of argument at pages 6, paragraph 15 to 10, paragraph 18, that a court may permit an intermediate appeal. But as the authorities show, midstream appeals of the sort currently intended are confined to those rare cases where justice might not be attained by other means. And we refer in particular to the judgments of the Supreme Court of Appeal in State versus Western Areas, in which we quote in extenso, or from which we quote in extenso in paragraph 17. And in the later case of Delport and others versus the State, from which in paragraph 18 we quote what is stated in paragraphs 27 and 28. And it is perhaps useful just to frame what I'm now going to say, to remind ourselves as to what the SCA, Justice Kachalia speaking, said there. The general rule, underpinned by Section 35(3)(d) of the Constitution, which of course provides that every accused person has the right to a fair trial, which includes the right to have the trial begin and conclude without unreasonable delay. So the general rule, underpinned by that provision, is against permitting piecemeal appeals. It is therefore in the interests of justice that criminal trials should commence and be completed without unreasonable delay, and that appeals should not be entertained before the trial is completed. However, the interests of justice may also require, in unusual circumstances, a departure from the general rule. That's the rider. And the requirement stated is unusual circumstances. The general rule therefore requires a remittal order, which was at issue in that case, not to be appealable unless unusual circumstances warrant this. What amounts to unusual circumstances, the court continued, obviously depends on the facts. In this regard, the court indicates a number of relevant considerations. Considerations of convenience, delay, and prejudice must all be weighed to decide whether the advantages of entertaining the appeal outweigh the disadvantages. The analysis doesn't require the court to give a decision on the merits, but it must consider the efficacy of the points raised to assess whether there is a reasonable likelihood that the advantages will materialize. Now, linked to that is the relationship between the interests of justice and combating the abuse of the processes of this court in the particular form which has manifested in recent times, in some cases, and is referred to as Stalingrad, the Stalingrad litigation strategy. Now, we deal with that in our heads of argument at pages 10, paragraphs 19 to 14, paragraph 31. And we submit that characteristic of this strategy is an interminable series of applications and other steps, including representations to the prosecuting authority and special pleas. And the accused deploying the strategy in those steps raises spurious objections to the investigation and the prosecution processes. Invariably, his points are dismissed by courts of first instance, but he then pursues them as far as he possibly can. And once the case is finally dismissed on appeal, he raises another point, or sometimes the same points again, and attempts to, this would be now be in another case, and repeat the process. Obviously, all the while, certainly while the appellate processes are ongoing, also relying on the rules which require, in certain circumstances, that the operation and execution of orders be suspended pending the outcome. We've heard our learned friends' submissions that Mr. Zuma's conduct of his defense cannot legitimately be characterized as Stalingrad. We've heard the trenchant criticism leveled a short while ago against Mr. Downer for saying that it does. We know that the term was first used in a case in the Durban High Court, the then Durban High Court, in this very matter, many years ago in 2007, graphically described by our late learned friend, Mr. Kemp, for Mr. Zuma. We know that a full bench in the High Court in Pretoria, in the matter of Democratic Alliance versus the President, held in 2018, that Mr. Zuma had adopted a Stalingrad defense strategy, which had cost the state an enormous sum of money, which the recovery of which was the issue in that matter. But most importantly, in the 13 October 2023 judgment of the Supreme Court of Appeal, dismissing Mr. Zuma's appeal under Section 18(4) of the Superior Courts Act against the 3 August 2023 judgment of the full bench of this court, bringing into effect its earlier orders declaring Mr. Zuma's private prosecution of Mr. Downer and Ms. Morn to be an abuse of the process and setting aside the summonses. The SCA found that, and I quote, "The private prosecution is part of the Stalingrad strategy announced by Mr. Zuma's counsel to Hugo J. over a decade and a half ago." And in the same judgment after giving an abbreviated history of Mr. Zuma's pre-trial litigation aimed at stopping or delaying his criminal trial, which in the last 6 or 7 years or so have included a permanent stay application and the 2 attempts now to remove Mr. Downer as the prosecutor, and his attempt at privately prosecuting Mr. Downer, the SCA made a further finding. This abbreviated history illustrates that on any reckoning, the scale of litigation, which is likely unprecedented in the South African courts, justifiably attracts the epithet Stalingrad. That judgment is final. An attempt by Mr. Zuma to seek a leave to appeal to the Constitutional Court against it was dismissed. The date is given of that dismissal in the state's chronology, which is in the little bundle at page 41. It starts, and it's in paragraph 12 on page 44. That occurred on the 20th of February 2024. So, under our rules relating to issue estoppel, apologies, my lord, it's on page 44, paragraph 12, and I will return to the chronology because it's relevant to another point which was made today. Paragraph 12. So the dismissal of that application for leave to appeal rendered final the Supreme Court Appeals judgment in the 18-4 appeal, and it had the effect that the issue of whether Mr. Zuma has been engaging in a Stalingrad litigation strategy that is raised judicata between the parties. So it's not that Mr. Downer alleges, it is that the SCA has found authoritatively that it is indeed so. And in your lordship's reasons for his judgment under appeal, which are the object of this application for leave to appeal, one of the points which your lordship made in relation to several of them is that the points raised are not new. They have been raised before and dismissed. And with the greatest respect to my dear and learned friend, Mr. Masuku, much of what he had to say today fell into that category. We heard, for instance, about Mr. Hofmeyer's affidavit, which rather dispiritingly we were told will not go away. We certainly hope it will, because in the matter of Zuma versus the Democratic Alliance and others, the others including the state, 2018, Volume 1, SA 200 SCA, generally but specifically at paragraph 80, the Supreme Court of Appeal rejected Mr. Hofmeyer's evidence, describing it or him as, and I quote, "The picture that emerges from the documents filed in the court below is of an animated Mr. Hofmeyer straining to find justification for the discontinuation of the prosecution. Mr. Hofmeyer discounted the objective facts, etc., etc." And when heavy reliance was placed on that affidavit in the permanent stay of prosecution application, which was dismissed in 2019 by a full court, the state had to deal with it again and made the point that the issues raised had been determined. Those concerned the so-called spy tapes and Mr. McCarthy's role, of which you heard again today. Undeterred, Mr. Zuma raised those points again in his special plea under Section 106(1)(h) of the Criminal Procedure Act, which obviously resulted then in Judge Kuhn dealing with them. As to Mr. Hofmeyer's affidavit, at paragraph 204 of his judgment, which is in the bundle of authorities that you have before you, at page 569, his lordship said, further, in the permanent stay application, Mr. Downer, who deposed to the answering affidavit of the state, duly authorised thereto, recorded that the state wasn't relying on the evidence and allegations of political interference in Mr. Hofmeyer's affidavit, which Mr. Zuma sought to rely on in those proceedings, and still relies on in these proceedings. The SCA and the spy tapes judgment had rejected Mr. Hofmeyer's evidence and allegations, including that the tapes indicated political interference, which would result in Mr. Zuma not receiving a fair trial. And my Lord, one needs only to page through that portion of his Lordship Justice Kuhn's judgment to see that many of the issues that you've had to grapple with again in your judgment on the main case were raised there, as well as some new ones raised today, like, for instance, Mr. Downer's failure to report the supposed political interference dealt with by his Lordship at paragraphs 225 and following, his alleged leaks to the media, the alleged leaking of confidential medical information, and so on. We say with firmly but respectfully that there are two things that are presently important. The one is that the SCA has made a finding that Mr. Zuma has been engaging in Stalingrad litigation. In other words, abusing the process of the courts. It is obviously a judgment which was pronounced looking at the concatenation of cases over time. It came up to a head in October 2023, and that was the factual finding. So up until that stage, and including the litigation then before the SCA, it found that this was Stalingrad. The only question becomes is the present matter, and in particular the attempt to seek leave to appeal, a continuation of that strategy? And your Lordship has our submissions. The striking similarities and overlaps between the points raised and rejected in the earlier cases which have now been held to form part of this pattern and what we see today are proof positive. And relating all of that back to the interests of justice. That's the overriding criterion. There has to be unusual circumstances which warrant a departure from the general rule, the default position that the matter must proceed. We submit that if your Lordship concludes, as with respect we submit he ought, that the present application is a continuation of that litigation strategy, then the intended appeal can never be in the interests of justice. My Lord, I see it's just gone 1 o'clock. Would your Lordship like to take the luncheon adjournment or for me to continue?
Yes. You may continue.
Thank you, my Lord.
Thank you. Well, if it's fine by everybody else, but with me, I'm okay.
Yes,
You
well,
may
it's
continue.
very, very fine with us.
Can you continue? Can you continue? Thank you. Yes, you may continue, Mr. President.
Thank you. So if I relate it back to the outline which I gave your Lordship at the outset, I've dealt with Section 316, I've dealt with Section 17(1)(c), and I've dealt in general terms with the interests of justice criterion. Further, as to the interests of justice, we would urge on your Lordship Justice Kuhn's analysis of the facts then prevailing in his 16 February 22 judgment, the portions of which we consider most relevant to this aspect are described and in many instances quoted in paragraphs 52 to 53 of our heads of argument at pages 22 to 24. In short, they amount to this. If during the course of the criminal trial it becomes apparent that Mr. Downer's involvement or leadership of the prosecution team is imperiling the fairness of the trial, then your Lordship may, either at the instance of the accused or indeed of your Lordship's own instance, bearing in mind your Lordship's duty to hold the ring and ensure that the trial is indeed the fair trial which the Constitution promises, you may intervene. But the proof...
By doing what, Mr. President?
Excuse me?
Intervene by doing what if the trial is already underway?
You can order that Mr. Downer be removed as the prosecutor. Because if you believe, as the court found in, for instance, Smythe's case, that the participation of a particular individual is imperiling the fairness of the trial, something which you have to guarantee as the custodian of the fairness of the trial, then you can. And His Lordship, Mr. Justice, couldn't said as much in the portions of the judgment to which we refer. I have no...
Yes, Mr.
Thank you. So the case which was made and which you did not accept was essentially based on a prediction. And you concluded that there was not reason to believe that Mr. Downer's participation would render the trial unfair. And all that I am submitting is that if that turns out to have been incorrect, not because you made a mistake, but because as the events unfold, they show that there is indeed a threat of or actual unfairness, then your Lordship will doubtless deal with it in the manner described. That then brings me to the grounds of intended appeal. These are not the grounds on which Mr. Zuma is saying that at this stage already you ought to have intervened, and that an appeal court may reasonably conclude that you were incorrect in not doing that. My understanding today, from what was said today, that the first so-called point in limine concerning the time taken for your lordship to decide the main application and then to deliver the second statement of reasons is no longer being persisted with. The two big points that were pressed on you today, and I will deal with the others as well because they were developed in the argument, were the contention that you ought to have dealt with a perception of bias on the part of Mr. Downer, and secondly, that his prior involvement during the investigative phase infringes a principle said to have been established in the second Glenister case against prosecutors being involved in investigations. So I'm going to start with those two. Now, if I understood the argument today, as it developed today, on the perception of bias, the reasonable perception of bias, as authority for the proposition that you were obliged to consider Mr. Zuma's alleged reasonable apprehension of bias on the part of Mr. Downer. His counsels referred to, in their heads, Roberts' case, again in their heads, the SAFU judgment on the recusal application, and today, Judge Kun's 30 January 2023 recusal judgment. And we must bear in mind that all of these deal with the test or proper approach to the recusal of a judicial officer. There's essentially a double reasonableness standard. A reasonable person in the position of the complainant, the person complaining of bias, must reasonably apprehend that the judicial officer is suspected or apprehend that they are biased. The thing is that in Porritt's case, the Supreme Court of Appeal made two findings which undermine this intended ground of appeal to the extent that it is rendered one that lacks any reasonable prospect of success. The first is that there's a fundamental difference between the role and functions of a prosecutor as opposed to those of a magistrate or a judge. And all of the authorities on which reliance has been placed concern the latter, the role of an adjudicator, a judge or a magistrate. In Porritt, the court said, by contrast, that in adversarial proceedings such as ours, it is inevitable that prosecutors will be partisan. That is in the sense that they conduct the case for one of two sides in a trial. In this instance, the state representing the citizenry of this country. They often carry out their functions vigorously and zealously. And so the court held that a prosecutor's role in a criminal prosecution therefore makes it inevitable that he or she would be perceived to be biased. It is an inherent part, in other words, of the adversarial criminal system that we have. But that does not, of course, mean that prosecutors are unconstrained in what they can do. The Supreme Court of Appeal went on to explain that Besides, obviously, and they don't deal with this specifically, but they deal with it by implication when discussing Smythe's case, to which I shall come in a moment. In other words, the role of prosecutors as officers of the court, not, for instance, to mislead the court. They specifically mention the duty on prosecutors to ensure that an innocent person isn't convicted. And the practical manifestation of that duty, as your lordship will be well aware, is a duty to disclose in certain circumstances harmful to their, in certain circumstances, facts which are harmful to their own case. In the days before the docket was available, prosecutors had to disclose a statement from which a witness for the prosecution had departed in a material respect. And probably today still at least have to point that out, especially if the defense is not perhaps as on top of things as they should be. And that would be to ensure that the judge is apprised of that material fact, so as to avoid an innocent person being convicted. But the corollary of that, and the second important finding, therefore, is that the protection that an accused person has in a criminal trial doesn't lie in any general standard of independence or impartiality required of all prosecutors, but in their right to a fair trial, which is entrenched in Section 35(3) of the Constitution. And the court was clear. It said what it had just said doesn't mean that a prosecutor can never be disqualified of grounds of actual bias or an apprehension of bias. The court said they will be disqualified, and that would obviously be by the criminal trial court, where the accused's right to a fair trial, where it affects the accused's right to a fair trial. And it was in that context, in paragraph 17 of its judgment in Porritt, that the court referred to the matter of Smythe, to which your attention was directed today. And it's perhaps as well briefly to have a look at the SCA's dealing with Smythe, bearing in mind that it's a judgment of a court in another country, albeit one which has a legal system with similar roots to ours, the Zimbabwean Supreme Court. The relevant passages are page 376 of the bundle. And at paragraph 17, after making the point that where a prosecutor's bias affects an accused's right to a fair trial, a prosecutor may well be disqualified, and the word bias used in that sentence includes an apprehension of bias as one sees from the first sentence. And the facts are then set out. Mr. Smythe ran several youth camps in Zimbabwe. He was charged with culpable homicide as a result of the drowning of a boy at one of them, and with 5 counts of crimen injuria arising from his alleged molestation of some of the boys at the camp. The prosecutor was the brother of a boy who had attended both camps and was a potential state witness. He conducted the prosecution in a manner which was manifestly overzealous, vindictive, and at times patently dishonest, in that he deliberately misled the court. The court removed him from the case, holding that the facts instill a belief that if the case were to remain in his hands, there is, at the very risk, a real risk that he won't conduct the trial with due regard to the basic rights and dignity of the applicant. It concluded that there was an inherent danger of unfairness to the applicant attended on his prosecuting at the trial, and accordingly held that Mr. Smythe had shown that his right to a fair trial is in jeopardy if he carries on. Now, with the greatest respect to my learned friends, this case is obviously distinguishable on the facts. None of Mr. Downer's relatives are potential state witnesses. He has, I respectfully submit, conducted the prosecution thus far in a restrained and professional manner. And he's done so while resisting, on behalf of the state, unjustified attempts to remove him, and resisting on his own behalf even a private prosecution which has been held to constitute an abuse of process. Listening to the submissions this morning, for reasons which are obvious and I'll have to deal with in a while, uncomfortable in some respects. Like, one can only imagine the discomfort that a career prosecutor such as Mr. Downer feels when having to face cases of this kind. But the point that I'm making is that he hasn't descended into the fray and acted in an unprofessional manner in response. Yes, the other side will disagree with parts of the affidavits that he's made, submissions that he's made, and vehemently and strongly so. But in all of those cases, the state has prevailed. Many of them have been examined by higher courts. Mr. Downer has not been vindictive. And he has never deliberately misled the court. He has dealt in his affidavits fairly and fully with the many allegations levelled against him in an attempt particularly to secure his removal, but also, for instance, to have the prosecution permanently stayed. And the best and perhaps the most relevant assessment of that is to have regard to his affidavit in the main case, his answering affidavit in the main case. The problems with the prosecutor in Smythe, there's no reasonable prospect of the appeal court finding on those papers that the cases are on all fours with one another. And that brings us to the reliance on the older decisions. Just need to find my note in connection with them. The one matter was Nechrini. If you'll just bear with me in a moment, which we submit are also distinguishable on the facts. Thank you. I know the cases. I just need to find my note. I apologize, my lord. I will find it soon. There aren't that many pages of notes for me to page through in order to find the references. I found them. The first matter cited by my learned friend Mr. Mpofu was R versus Nechrini. You'll recall that. That was a truly extraordinary case. The prosecutor was the complainant, the investigating officer, the witness for the prosecution, and the prosecutor. Mr. Downer is none of the above, but except the prosecutor, although he did, as we shall see in a moment when dealing with Glenister in a little more detail, perform certain functions under the relevant provisions of the NPA Act in connection with the investigation. The other matter was State in Kushabana. The first reference, by your Lordship may well have noted, it was 1948 4 SA 995 Cape, and in Kushabana is 1972 4 SA 633 Eastern Cape. In that matter, the prosecutor was the only witness for the prosecution. Now, my learned, my Lord, I've been asked by my learned friend for Mr. Zuma to request a 10-minute comfort break.
Let's make it 20.
Is it please?
Right. Cut it, James.
Kushabana's case, and you'll recall that one of the features that those cases had in common was that the prosecutor was a witness for the prosecution in both cases. Mr. Downer will not be a witness for the prosecution in the present matter. My learned friend, Mr. Mpofu, however, said that his side intend calling Mr. Downer, that presumably now be as a witness for the defence, to testify about the alleged leaking of Mr. Zuma's medical information to Ms. Morn. All that I wish to say in that connection is that the evidence that Mr. Zuma intends to elicit from Mr. Downer is irrelevant to the merits of the case, the determination of the charges against the accused, and hence it will be inadmissible. And it would be passing strange if by using such a gambit the defence could achieve a situation whereby the prosecutor had to withdraw. Another submission made this morning that I have to address lastly when dealing with this reasonable apprehension of bias point concerns the fact of the private prosecution. If I understood the submission correctly, it was that the fact of the private prosecution, albeit discontinued, for now suspended, is a basis, and the submission went further. The fact that the private prosecution was held to be an abuse of the process of this court compounds the problem as to the reasonable perception of bias. We respectfully submit that there is an inherent circularity or bootstraps element to that argument. The thing is that there is, as your Lordship pointed out, currently no private prosecution. The summons has been, the orders declaring the summons unlawful and invalid are in effect. The orders saying the prosecution is suspended are in effect, and that will remain the position unless and until Mr. Zuma succeeds with his attempts to appeal against the full court's decision that it was indeed an abuse of the process of this court. We respectfully submit that a private prosecution which has been found to be an abuse of the process of this court, it was found amongst things to have been instituted for the ulterior purposes of having Mr. Downer removed as a prosecution, an explicit finding, that could never sustain a reasonable apprehension of bias, for the simple reason that inherent in the reasonableness standard is an objective assessment. A reasonable person would and could never think that, and frankly the court could never countenance that as a basis, because it would in effect defeat the finding of the full court. So we submit that this intended ground of appeal, one of the two big ones argued today, firstly is founded on a fundamental misconception of the applicable law relating to the role and function of prosecutors, and secondly it is rooted really in a private prosecution which has been found to be an abuse of the process of the court. And for that reason we respectfully submit that it has no reasonable prospect of success. That then brings me to the second big point, which was argued both by both my learned friends, the point which is founded in Glenister. Now the judgment in question is a minority judgment. It's paragraph 76 to 78, and it's correct that the majority didn't expressly disavow that, and the points on which they disagreed with the minority are different ones. So let's accept for present purposes that they acquiesced, the majority acquiesced in that. But if I may ask the court to turn to the bundle at pages 144 and 145, where one finds the paragraphs relied on by Mr. Zuma, paragraph 76 to 78. What one sees there, two things which are of present importance. In paragraph 77, His Lordship Mr. Justice Ngobo, then the Chief Justice at that stage, said, or criticized or found to be incorrect, the assumption that the Constitution, and I look at the word, requires the NPA to be given the power to investigate crimes as a necessary function that's incidental to instituting criminal proceedings. In other words, it was a constitutional requirement, was the assumption which His Lordship found to be wrong, that had to happen. And he pointed out that the powers expressly given by the Constitution to the police service by section 205, and consequently he says it's wrong or cannot mean that the powers vested in the police service must be assigned to the NPA. In other words, that's a constitutional requirement. So he says that doesn't mean that a specialized crime fighting unit must be established in the NPA, which was really the issue in that case, which, as you'll recall, my Lord, concerned the transfer, if I can call it that, of the functions of the former Directorate for Priority Crime Investigation of Scorpions to the former Scorpions to, that's the DSO, Directorate for Special Operations, to the Directorate for Priority Crime Investigation of Police Unit, called the Hawks colloquially. So the finding was a different one, and it said that there was no constitutional requirement to locate any investigative authority in the NPA. Non-constat that the law could not validly do that. Now it's true that in the following paragraph 78, His Lordship continues saying, given the provisions of sections 179 and 205 of the Constitution in particular, those are the ones dealing with the NPA and the police respectively, the assignment of the powers to investigate crime to the police and the power to prosecute to the NPA, it's indeed doubtful whether the power to investigate crime can be said to be incidental to the power to prosecute crime, which is one of the powers conferred on the NPA by section 179. But here's a crucial portion. Happily, in this case, we do not have to consider the question of whether Parliament had the power to confer full-blown investigating functions and powers on the NPA in the light of the provisions of those. So that question is not dealt with. And why is that relevant? It's relevant because the investigation which has culminated in the present proceedings was conducted by two investigating directorates within the NPA. The first was the Investigating Directorate, Serious Economic Offences, and the second was the Directorate of Special Operations, to which I have just referred. But that was not done without a legal foundation, because the National Prosecuting Authority Act, specifically in sections 7, 28 and 29, created or made provision for the creation of and empowered those two bodies within the NPA. And the significance of that is that there is no challenge in the main case, or indeed belatedly today, to the constitutionality of those provisions. And as the Constitutional Court held in the Sheikh case, the reference is given in our heads of argument at footnote 46 on page 38, dealing with a similar challenge, this time by Mr. Sheikh, to Mr. Downer's role in the investigation. The question then becomes whether Mr. Downer acted within the bounds of those provisions. And in that regard, Mr. Downer's evidence becomes important. There was a submission to your lordship today that his evidence, that he didn't address this in his affidavit in the main case. We respectfully refer you to paragraphs 148 to 160 and 163 of his affidavit in the main application, which are at record pages 585 to 592. And what he did there was, by necessary implication because of the method that he adopted, which was to refer back to the Shape case, including the factual findings of the Constitutional Court as to what he had done in that matter, to say, this is what I've done. It was found by the Constitutional Court in the Shape case not to have involved out-of-bounds activity, and essentially he said therefore that the challenge to his role was in the investigation in the present case is bad for the same reasons. And I respectfully submit that one can summarize what he said there as the following, and this concerns involvement in the investigation. One, he conducted witness interviews under Section 28 of the MPA Act, and he guided the investigators. You'll recall that in that case there was something made of, or considerable amount made of, his presence outside premises which were searched in Mauritius pursuant to a request for mutual legal assistance which was granted by that country, where he was shown documents and asked whether they were covered, etc. And he answered those questions, gave guidance in that way, and generally he gave guidance to the investigators. But beyond that, he has acted as the prosecutor. But the simple point is that what he then did was found by the Constitutional Court in that case not to be constitutionally offensive. It was intra vires, essentially. And we accordingly submit that absent the direct challenge to the provisions authorizing him to do what he did, his limited functions, presaged by and deliberately stated by Justice Ngobo not to have been an issue raised in Glenister 2 and the passages on which they rely. So absent that, and given the outcome of the very similar challenge raised in Sheikh, that this court can and should approach this aspect on the matter on the basis that the Glenister point, if I can call it that, does not have a reasonable prospect of success. The simple fact of the matter is Glenister did not find that something, that a scheme such as is created by Section 7, 28 and 29 of the NPA Act is unconstitutional. It was deliberately left open, and Sheikh found that what Mr. Downer did do was intra vires, within his bounds. There was some reference to, again, to Mr. Downer's indispensability. And we would simply emphasize that there's no question of this court having found that Mr. Downer must stay on because he's indispensable, even if his involvement will imperil the fairness of the criminal trial. That was not what your lordship found. Your lordship found that his that you had no basis to conclude, based on everything which had been adduced to you, that his involvement would have that effect. And I can do no better than read your Lordship's own conclusion in paragraph 11 of your Lordship's reasons. Having considered all of the grounds relied upon by Mr. Zuma, both individually and cumulatively, I was unable to conclude that Mr. Zuma's right to a fair trial would be violated if Mr. Downer remained the prosecutor in this matter. Now, with respect, that finding presents multiple insurmountable hurdles to the intended appeal. The first is that it shows that your Lordship, with respect, correctly approached the case before you through the prism of section 35(3). The second is, in relation to the particular aspect I'm dealing with, your Lordship found that there was no case made out. And it's in that context that your Lordship made the remarks that he did about accused persons trying to choose or pick their prosecutors. We respectfully submit that your reasoning on this point is wholly unobjectionable, and that as with the reasonable apprehension of bias point, which is rooted in a fundamental misconception of our law, as this one is too, it's no exaggeration to say that the point is hopeless. And that disposes of the third point in limine taken by the accused, Mr. Zuma, in this matter, namely that you should allow an appeal because you don't deal expressly with the reasonable apprehension of bias point and with the Glenister point. What you do deal with is the central issue of the fairness of the criminal trial, looking at the underlying allegations. And with respect, it is unfair criticism of a presiding officer in a case where a welter of points are taken and the presiding officer deals with those which, in their opinion, have to be covered in order to explain the reasons for their decision, to then criticize them for not dealing with what in effect are hopeless points. I suppose one could do it, but it would unnecessarily prolong a judgment and not contribute anything to the central finding made by your Lordship that Mr. Downer's continued involvement would not lead to a violation of the 35(3) rights of the relevant accused. That then brings me to a submission which I really struggled to understand, which was that you gave your decision on the 20th of March 2024, and in giving reasons on 11 September 2024, you relied on supervening events. And I must confess I listened and made the notes, but I really struggled to understand the point. May I ask your Lordship just briefly to go to the chronology which we provided, the contents of which are not in dispute. It's in the little bundle at page 41. And it concerns the private prosecution of Mr. Downer and Ms. Moon. And the key dates are those given in paragraphs 2, 3, 4, 7, 8, and 12. Those dates start with the full court judgment of 7 June 2023 holding that the private prosecutions was an abuse. The full bench is granting of the applications under sections 18(1) and 3 of the Superior Courts Act on the 3rd of August, putting that into operation. Mr. Zuma's bringing of an application, exercising his automatic right of appeal on the 14th of August. One sees that that's the 18(4) appeal. In paragraph 7, the SCA dismissing that appeal on the 13th of October. On the 25th of October, Mr. Zuma applying to the Constitutional Court for leave to appeal against that, paragraph 8. And then on the 20th of February, the Constitutional Court, that's 2024, dismissing Mr. Zuma's application for leave to appeal. Now, all of those things occurred before the 20th of March 2024. What happened after the 20th of March? You removed the matter from the roll on the 9th of April, something on which you placed no particular reliance. We all know, we were all there, what happened on that day. And then Mr. Zuma tried to keep alive a parallel set of appeals, which was an appeal against the full court's main judgment of the 7th of June. He failed with that application in the full court. That happened, as appears from paragraph 5, on the 11th of September 2023. He failed with a petition to the SCA on the 7th of December, as we see from paragraph 10. And he then applied to the President of the SCA on the 11th of January for a 17(2)F referral back to those two judges. 2 days after your ruling, the President of the SCA dismissed that application, and he then wanted to take it forward to the Constitutional Court on the 19th of April. I have to say that it was done in the teeth of a judgment by the CC, which says that there is no appeal against a 17(2)F refusal, but we await the word of the Constitutional Court on that. But the crucial point, my Lord, is this. Having lost the immediate enforcement proceedings, conclusively and finally, before your Lordship made the order he did on the 20th of March last year, these intended appeals have had no effect on the status quo, which is that there is currently no prosecution of Mr. Downer and Ms. Morn. Hence, my not being able to follow the point which was made. It just seems to me to be disconnected from the facts, and consequently not one which will sustain a reasonable prospect of success on appeal. Then, in oral argument today, there was argument addressed to you about the alleged unlawful disclosure of Mr. Zuma's medical information to Ms. Morn. And the submission made on the other side is that there is sufficient and ample evidence pointing to Mr. Downer having been involved in that. What I need to do is to just show you one or two parts of the judgment of the full court in the main case on the abuse, because they become relevant to a point of res judicata which I'm going to raise. So the sequence of events, one sees that in the full court's judgment of June 2023, holding that it was the prosecution was an abuse of process, at pages 280 to 281 in paragraph 105. That is where one finds the evidence on this, and it goes to the potted factual account which my learned friend Mr. Mpofu gave today. The full factual account is set out in that long paragraph with 10 sub-paragraphs on pages 280 to 281. What the full court then did was it gave its evaluation of the contention that as to the charges levelled against Mr. Downer in connection with this. And you'll see from paragraphs 106, 107 and 108 that the full court aligned itself with the dealing with and findings on this issue by Justice Kuhn in his judgment dealing with the special plea or dismissing the special plea under 1061H. Those findings were: 1, the documents having been sent to the court by the time they were disclosed to Ms. Morn were not confidential, they were public documents. And in any event, the confidentiality was waived because the documents were also filed, if there was any, it was filed by Mr. Zuma as an annexure to his affidavit in support of the application for a postponement. The further factors that dealt with in paragraph 108 is that Mr. Downer had nothing to do with the relevant exchange between Ms. Morn and me. It took place between the two of us. She asked me for the documents that had been sent to the court and to the other side in unsigned form at that stage, and I said fine, and sent them to her on condition that she not publish anything until the signed version had been filed at court, which it was the next morning, and she published thereafter. In the meantime, she received Mr. Zuma's signed papers, which included the same thing. And why do I emphasize this? Because the full court concluded that in 109 that the charge against him, Mr. Downer, who had nothing to do with any of this, was unsustainable, and consequently the prosecution was an abuse. Now I know this judgment is not final, because there are these attempts that we've seen still to get it appealed. But what is important is that in the Supreme Court of Appeals judgment dismissing Mr. Zuma's Section 18(4) appeal, the Supreme Court of Appeal referred to, aligned itself with, and affirmed the findings made by the full court as well as by Justice Kuhn. And I shan't take you to the paragraphs in the interests of time, but they are paragraphs 11 and especially 12 at page 676, paragraph 28 at page 683 in the bundle, and paragraph 30 at page 684. If you wish, I'm very happy to take you there. The first is at 686. Sorry, 676. That's the last. And you will see, for instance, in paragraph 12, the affirmation of the findings by Kunjay and by the full court in question. Paragraph 28 at 683. It's especially from just above the letter B and to the end. And again at paragraph 30. Where the conclusion is that there was no cognizable offence committed by Mr. Downer. And far from there being sufficient and ample evidence pointing to the allegation, such evidence as there is, and the evidence which is covered by those judges, is the only evidence which is and has been available. And the conclusion by the Supreme Court of Appeal was that the case against Mr. Downer, Ms. Moon, was so bad, there being no factual foundation for it, that it was an abuse of the process of the court. That finding is final. And Mr. Downer's, in his answer in the main case, which your Lordship is well aware, he put up a detailed and substantiated denial, conformably with everything which was subsequently found. And that is really the end of that point having any prospects. But then your Lordship is most curiously criticised for finding incorrectly that Kunjay dealt with this matter in detail in his judgment. My Lord, the matter which Kunjay didn't deal with was whether a criminal offence was, whether the matter should be referred, if I recall. But if your Lordship goes to Kunjay's judgment, it's in pages 577 to 583, paragraphs 246 to 267. It's under the heading, the leaking of confidential medical information. It goes on for pages. And it reaches the conclusions which the full court summarized and to which I have referred. Again, my Lord, this shows that this second pillar, far from being a pillar, is no pillar at all. It's like candy floss. It might have a form, apparent form, but there has no substance, no reasonable prospect of success. This morning, again, the contention that your Lordship erred in relation to Pillar 3 was advanced, having previously been put up in the papers on behalf of Mr. Zuma and the heads. But there is a fundamental difficulty with these 8 conversations to which my learned friend Mr. Mpofu referred, and that is that none of the utterances ascribed to him support Mr. Zuma's allegation that Mr. Downer disclosed to Mr. Sol information relating to his case. You don't see any mention of Mr. Zuma or his case. The reference to the German investigation, which you heard again this morning, that concerns of an aspect of the arms deal which is unrelated to this case. And furthermore, I respectfully say this point has been flogged to death. So much so that the very transcripts were in Mr. Zuma's permanent stay application, the one that was dismissed in 2019 by the bench headed by His Lordship the late Mr. Justice Nguni. They resurfaced again in the papers before Kunjay, who inter alia made the point that this is an attempt to resuscitate a point which is res judicata. All attempts by Mr. Zuma to appeal against those dismissals failed. So we consequently submit that there is no prospect of an appeal court being persuaded that Mr. Dana should be removed because of what he said, what he's recorded as having said to Mr. Sol. The provenance of those transcriptions and the recordings remaining a mystery to this day. Bear with me one moment, my Lord. My Lord, the last submission made to you today was the cumulative impact or cumulative weight. My understanding is of the submission, based on, ultimately in law, it was rooted in His Lordship Mr. Justice Kuhn's recusal judgment, and particularly at paragraph 49, where he said the accumulation of all of the things that he'd considered, even if one, more, or all of them were insufficient, viewed in isolation, nevertheless sustained a reasonable apprehension on the part of a reasonable person in Mr. Zuma's position of bias in his part if he had to re-adjudicate these matters. You were urged to follow a similar point here. And although the test is a reasonable prospect of success, and the other one is a reasonable apprehension of bias, with the word reasonableness features in both, we respectfully submit that the real issue that you are grappling with, depending on the prism that you're using, if it's the interests of justice, the real issue is where there are unusual circumstances which justify the departure from the general rule of not allowing appeals of this kind, or finding that justice might not be attained by other means, to use the Western Areas approach, or if we're in section 17(1)(b) of the Superior Courts Act, that there must be a compelling reason. Every which way one looks at it, what they have in common is exceptionality. There has to be something exceptional about this case which would allow the intermediate appeal which has been sought. And once that is appreciated, then the reliance on His Lordship Mr. Justice Kuhn's approach to the double reasonableness standard in a recusal application is shown to be misplaced. Because what we are dealing with here is a test or a threshold much higher than a reasonable perception of bias in the mind of a reasonable person in the position of a litigant about a judge. And I fail to understand, and this is my submission, how it can sensibly be contended that even if each one of these grounds of appeal viewed in isolation is a featherweight, that somehow they will tip the scales in favor of deviating from the default of requiring that this matter proceed to a trial on the merits. Those are the submissions for the state.
Yes, thank you. Yes, reply, Mr. I suppose, is it only going to be you who's going to reply?
Only me, my lord. Yes.
Yes. I know, Mr. Mpofu, we didn't set the timelines.
Yes.
This matter.
No, well, you already have a discount, my lord. Mr. Masuku is not going to talk this time. My lord,
Insist on replying.
no. If he does, I'll overrule him.
Yeah.
My lord, let me just start with something that, shall we say, must be a slip of the tongue on the part of my learned friend, Mr. Breitenbach. Because knowing him as I do, I don't believe that he wants to deliberately mislead the court. But he has made the suggestion that the conversations with Mr. Soul did not concern Mr. Zuma, or that he was not mentioned in those conversations. Well, that's just patently false. If your lordship goes to 454 of the bundle, of the record. Of the record, my lord. Yes. If your lordship doesn't have it, I'll just read it out. It's very brief, yeah. You know, this is...
Sorry, you said it's page
454, my lord.
454.
It's conversation, as I said earlier, the conversations there are 8 separate conversations. Under conversation number 2, Mr. Soul says something, Mr. B means Billy, Downer says something, and then S says at the bottom. That's another thing I wanted to ask you. All the decisions, this fight with Zuma, not everything has to take place in terms of the ICCMA. There are processes and processes that can be used for the exchange of info. So it's there in black and white. It's clear. There's only one Zuma that they must have been referring to. So that's there's no other person or case where the discussions with Mr. Soul were about. But that aside, my lord, I'm going to really briefly address a few of the issues, almost in point form, my lord, because quite frankly, there is nothing that has been said by Mr. Breitenbach that even remotely disturbs the grounds that we have raised. So for what it's worth, I'm just going to very briefly, as far as the, my lord, also we have to remember that there's this permanent stay application which has been brought by accused number 2. And your lordship was asked to fix timelines. I'm just flagging that. Timelines of exchanging of pleadings in relation to that. But that can even be done between the parties. But the only reason I'm raising that, my lord, is to flag the fact that irrespective of what your lordship finds here, there is now, as a fact, a permanent stay application filed by accused number 2. That permanent stay application means that it has to be entertained to its logical end. And although we don't have firm instructions, I can hint to your lordship that we're likely to take a position. I've just paged through it because we also received this morning as to whether we support that application or not.
You're likely going to align yourselves.
Your lordship is quite correct, yes. But whether we do or not, the point is that as we speak now, and that's why my learned friends have always been here, the trials are intertwined. And I just want to say this, my lord, without predicting what will be in our affidavit. The issue is very simple. If indeed, and our learned friends have put in their affidavit, I don't have to bore your lordship with the details, that their witnesses have just died. It's an act of nature. And therefore the case can no longer proceed against them, rightly or wrongly. Now, as we know that this case revolves around the so-called encrypted facts, really, if you cut all the legalese. Now, if the people who are the owners of the encrypted fax are no longer there to either defend it or whatever, that's the end of the case. So all I'm saying is that should the permanent stay application succeed, then that on its own, and please, I hope nobody's going to accuse us of Stalingrad, because it's not us, it's accused number 2 who are bringing this application. If we oppose it, it will be on the base.
Let's just shelve that for a moment.
Yes,
and
yes, yes.
Focus on this one.
No, my lord, I'm just raising it in relation to this case to say that it's an issue that I'm going to deal with, this so-called Stalingrad nonsense. Yeah. So, Your Lordship, yes, let's put that to bed for the moment. Now, to the first point. The Section 316 point, Your Lordship, is a non-starter. My learned friend, Mr. Breitenbach, in his own mouth says that, 1, the so-called general rule that Section 316 must only be done after conviction is subject to all those exceptions. Your Lordship knows, all lawyers, once you see the word general rule, it means
there has to be an exception.
There have to be exceptions, yeah. And the exceptions in this case include interest of justice. Interest of justice in this case has been specifically pleaded. So that's the end of that objection. Besides, my lord, the other objection based on Section 1 of the Superior Courts Act, the definition of appeal, also does not assist them, because that objection says that an appeal is defined as I'll paraphrase, my lord, just to save time. An appeal is defined as an appeal that excludes those aspects that are found in or a case that emanates from the Criminal Procedure Act, basically. Now, that might then have been so when it comes to the Section 106 application, because as we know, Section 106 comes from the Criminal Procedure Act. But that's irrelevant in this case. This case doesn't come from Section 106 of the Criminal Procedure Act. It comes from a recusal application. A recusal application has got nothing to do with the Criminal Procedure Act. It's just a recusal application. It could have been a civil case or whatever it is. A recusal application is a common law right that has nothing to do with the Criminal Procedure Act. So that means the Chapter 5 exclusion doesn't apply here. Thirdly, my lord, again, I won't make the references to save time. You'll find in the heads of the state 2 places. I think one of them is on page paragraph 77 of their heads, where they say that the case, they say Mr. Downer must be believed because Plascon Evans applies, right? Now, once you say Plascon Evans applies, it means you are accepting that it's a Section 6 application. I mean, Section 6, Rule 6, application. So if it's a Rule 6 application, then how can you say that Section 17, which is an appeal against motion and all motions, doesn't apply? It's just an absurdity. But anyway, that's the end of that. The second issue, my lord, that, Mr. Downer, I'm so sorry, Mr. Downer, Mr. Breitenbach then says that this appeal will not resolve all the issues between the parties. Now, in simple English, what that means is that the issues that we are dealing with would not amount to either an acquittal or a conviction. But that's false, because we know that those issues, even to the extent that they were raised in terms of 1061H, my lord, may lead to an acquittal. That you will find, my lord, if you go to Section 1064 of the Criminal Procedure Act. It says, An accused who pleads to charges other than a plea that a court has no jurisdiction to try the offense, or an accused on behalf of whom a plea of guilty is entered. And by the way, former President Zuma has entered a plea of guilty.
A plea of guilty.
Of not guilty in the section 115. Section 115. My Lord, my learned co-pilot thought I was throwing in the towel.
For a moment I was going to ask, why are we here?
Exactly, my Lord, yeah. On behalf of whom a plea of guilty is entered by a court, or in this case a 115, shall, save as is otherwise expressly provided by this act or other law, be entitled or to demand to be acquitted or may be convicted. In other words, my Lord, the so-called special plea, just like even in civil cases, if I raise a special plea in a MVA case, if that special plea succeeds, that's the end of the case. So it's not true to say that these issues would not result in an acquittal or conviction either way. But be that as it may, my Lord, let me deal with one issue really that in all conscience cannot be left. You know, it is, my Lord, it's this Stalingrad thing is really, really mischievous. And I said in the morning, I'm not going to deal with it unless if it is relied on. And I can see that it is relied on. Well, the time has come to put this thing to bed once and for all. You know, because it doesn't matter how many times this court has addressed that. It gets every day we're here, we're told about this thing. When, before your Lordship's time, when we wanted a postponement pending reconsideration by the president of the SCA, Stalingrad, we were told. Justice Kuhn said, what do you mean? I can't deny somebody's constitutional right to wait for the appeal just because you're saying it's Stalingrad. Done. When there was the recusal application of Justice Kuhn, Stalingrad, and Justice Kuhn said, but if I am conflicted, I have to go. Stalingrad or no Stalingrad. But when, in your Lordship's time, last time, when we said we want reasons, what did Mr. Downer say? Stalingrad. But your Lordship said, I have to give reasons, and gave the reasons. So please, we don't want to hear this absolute insult anymore. Anybody who mentions Stalingrad must know that they are just insulting. Why is this thing abused? It is said that Mr. J. Kemp said in front of Justice Hugo that the strategy he was following was Stalingrad because he would fight from village to village. I'm paraphrasing. Now, my Lord, firstly, it's condescending on us to think that we are following the late J. Kemp's strategy. That's a very serious and racist, for that matter, assumption that we can't think of for ourselves. But secondly, even if it's taken that my late learned friend, Mr. J. Kemp, made those remarks, surely, my Lord, all he was saying, you know, it's people who don't know history. The battles in Stalingrad were not for delay. The battle in Stalingrad simply means you fight on every front that is available. So to turn that into a swear word is to undermine the Constitution and also to desecrate the memory of Advocate J. Kemp. Because surely that's not what he was saying to Judge Hugo. He was simply saying, we will fight every available opportunity which is in the Constitution. Now, to insult someone who's using the Constitution is to insult the founding fathers and mothers of our Constitution. Because if they didn't want to put those protections in the Constitution, then they wouldn't have put them. I can tell you now, anyone who cares to hear, we are going to use every protection in the law legally that is available. You can call us what you want. And so the so-called Stalingrad thing must be rejected with the contempt it deserves. So let me close it like this, my lord. If by Stalingrad it is meant that you use the rights available in the Constitution, we're guilty. We are doing Stalingrad because we're going to use the rights in the Constitution. But if by Stalingrad is meant something in some dark rooms and that is done with dark glasses to subvert the process, then we reject it. Okay, I hope that's the last we hear of the Stalingrad. And now, the third issue, my lord, is a very important issue. Your lordship yourself even participated in that. By the way, that's the end of the case because it's a concession. So Mr. Breitenbach says to your lordship, well, if the threats, I think is the word, that we are making about Mr. Downer's conflicts surfacing later are correct, then your lordship at that point would be justified to kick out Mr. Downer. That's a very serious concession. So let me say two things. It's not if. We have said to this court, my lord, that in relation to the 14 points decided by Kun J, subject to the qualifications that he put, we are going to call Mr. Downer as a witness. He's going to be called. It's not if. It's not a threat. It's a fact. It's going to happen. So if that happens, my lord, and according to Mr. Breitenbach, at that point your lordship can remove Mr. Downer. You might as well remove him now because it's going to happen. I can assure you, as the sun comes from the east and sets in the west, that we're not going to leave unchallenged the issues that we raised before Kun J, including Mr. Downer's. So it's not a threat, it's not a prediction, it's going to happen. And as a matter of fact, therefore, so the ridiculous proposal is then this, my lord, that your lordship must say, no, I can't entertain this appeal, and wait in the middle of the trial to the time that Mr. Downer is called as a witness. And only at that stage, in the middle of a costly trial, then say Mr. Downer is disqualified. What is that? And the distinctions made by Mr. Breitenbach of the cases of Negrini, Smythe, and all those other cases are non-distinctions. Because he talks about a case, one of those cases, Smythe, where the person was a potential witness, the prosecutor, and he was removed. Well, this one is not a potential witness, he's an actual witness. So, if anything, that distinction works in our favor. And this also says none of Mr. Downer's relatives is going to be called as a witness. We agree. It's not his relatives, it's him who's going to be called as a witness. And then he says, all of the cases we cited depend on the recusal of a judge or a magistrate. That's not true. Smythe's case is about the recusal of a prosecutor. All the remarks made by Kun J in his judgment are about the recusal of a prosecutor. And then we are told that one can imagine the discomfort Mr. Downer feels. Well, this court is, Section 35 is not about the protection of Mr. Downer's discomfort. It is about the protection of the accused person in this case, which is Mr. Zuma. So so that's the first concession, which clearly, on the basis of which just that alone, we leave should be granted. And then the other one, second concession, or confession, maybe I should call it, not even a concession, is Mr. Breitenbach tells this court that the prosecution of Mr. Downer and Ms. Mon is suspended as we speak. Now, that is true, or let me put it that way. If that is true, then the situation is even worse than what we imagined. Because if your Lordship's judgment was saying there's no prosecution, but the prosecution, according to Mr. Downer, is suspended. But it's irrelevant. In other words, my Lord, if to use your Lordship's, it's alive, but it's it's sleeping. But sorry, thanks. But my Lord, that's thanks. That's even that doesn't matter, my Lord, because take Mr. Breitenbach says he didn't understand the point about the 20th of March and so on. And then he gave a long list of paragraphs which he read. Well, he doesn't have to read all those paragraphs. The one that he jumped is the one he must read. It's paragraph 9. It's a paragraph at page 44 of the small bundle. This must be a big point. There's music. Thank you. Apologize, my Lord.
On behalf of who?
On behalf of Mr. Masuku, I have to sell him out. my Lord, the paragraph 14 of that at page 44 simply says, in black and white, on 9 April 2024, this court, per Qili J, removed the private prosecution from the roll, and in accordance with a tender made by Mr. Downer, ordered that such removal was without prejudice, and so on, and further that if the full bench main judgment on 7 June is setting aside the summons, is itself set aside, Mr. Downer and Ms. Mon will again appear as accused in the private prosecution on a date to be determined. So that's simple. I mean, even a child will tell you that 9th April 2024 happens after 20th of March. So that's the end of that. So if on the 9th of April, Qili J, your Lordship, was still postponing the matter and simply saying that they must not appear, then it was alive. And it was alive on the 20th of March as well. It's a simple, I don't know what it is that Mr. Breitenbach doesn't understand about that. And according to him, it's still alive even now. Then the last, the second last point is the Glenister. I don't want to waste time on this. I won't repeat the things. My Lord, to the credit of Mr. Breitenbach, they've now abandoned, well, I don't know, maybe it's a strong word, but at least they're no longer pursuing this false distinction that the passages we rely on were coming from the minority judgment. And that is a correct concession, my Lord, because we know that judgment, we know, was one of those close calls, 5-4. But in the judgment, and as Mr. Breitenbach correctly considered, in the judgment of Ngobo CJ, which is the so-called minority judgment, where there were 4 judges, that's where the passages come from. In the judgment of Musaneka DCJ and Cameron J, which was the 5, they effectively did not overrule that. So you can say that it's 9 judges on the points that we rely on. And So in the minority judgment, it was Ngobo, J, Brandt, Mogoeng, and Yakub. And then the other one was Musanega, Cameron, Froneman, Kabinde, and Square. And all of them, at least on the points that we rely on, were ad idem. Then there's this point, my lord, about where your lordship says in his judgment, I think it's around paragraph 11, that your lordship agrees with Mr. Badlander that it would be a mockery if an accused were to choose a prosecutor. Well, we agree. We also agree with Mr. Badlander and your lordship, except that that has nothing to do with this case. This is not a case where Mr. Zuma says, I want Mr. Mkhize or Mr. van der Merwe to be the prosecutor. They can bring any prosecutor. All he's saying is that he is not choosing a prosecutor. He's simply saying this particular prosecutor is disqualified. That happens every day. So if you come here and you say, Kili J must recuse himself for this and that reason, we're not saying, no, we want Judge X or Judge whatever. We are simply saying that that particular person must be recused. So we don't need a lecture from Mr. Badlander or anything, or anybody about that an accused person cannot choose a prosecutor or a judge for that matter. We know that. I've already made this point. I've already covered the point. If I can round off then, my lord.
Yes.
My lord, this is as we started this morning, is a typical case in which your lordship is constrained by all the rules of justice and where it is in the interest of justice to, shall we say, have this matter of the suitability or non-suitability of Mr. Downer to conduct this particular prosecution tested or referred to another court. Because the flip side of that is, as somebody once said, too ghastly to contemplate. Because what it would mean is that, honestly, we have to go through an entire trial and then only at the knowing with a compromised prosecutor, where we know that the outcome of that, my lord, is sorry. It's just I think it was on page 14 of our bundle, my lord. Kun J explained what would happen if on the recusal, if the recusal is successful. He says, paragraph 24. A fortiori, if it is found at the end of the trial that a judge, and again, mutatis mutandis, that a judge should have recused him or herself or a prosecutor, the trial will be a nullity, will fall to be set aside in toto, and will have to commence de novo, in other words, afresh, at considerable cost and inconvenience. The above are material considerations which must be present in the mind of any judge when considering the possibility of a recusal. Yes. So any recusal, this is not a joke. It's a question of saying that this court and this whole country and the accused and the witnesses and on must go through a charade which is destined, almost certainly, to be a nullity. For what? Just to satisfy the proclivities of an NPA that is grossly irresponsible and takes its cue from newspapers. I understand now that Shamila Batoy even has classes there at the NPA about Stalingrad. But a situation that is created by the media for its own purposes, not as a legal term. So this court cannot entertain such absurdities. And the sooner the NPA understands that its job is not to pursue, for whatever reasons, at all costs, a particular accused, for whatever reasons that they have, and their job is simply to be detached, to take and deal with this matter passionately, dispassionately, as they would, my lord, about any matter. If there was somebody who stabbed someone else and so on, and it turns out that the prosecutor is related to the one who has been stabbed, I'm sure the NPA would not even hesitate to say that prosecutor must be changed. But here they're clinging for dear life to an unsustainable situation and blaming us for that. It's completely ridiculous. We've been told about 20 years. That 20 years includes 9 years in which the matter was dead. The Lordship knows the history of the matter. That 20 years includes 4 years, at least that I've been involved in this matter, since the Section 106 matter. That 4 years, the delay of that 4 years since May 2021 cannot be thrown in our direction. We raised a Section 106 point. Justice Kuhn, in his judgment, unfortunately dealt with matters and the merits. That resulted in his recusal and Your Lordship's introduction. And the Justice Kuhn said himself, my Lord, I have to make this point. We are the people who said here on the 26th of May to Justice Kuhn, please deal with the issue of 106 and the removal of Mr. Downer in one matter. That's what we said. The Stalingrad people, we said that. We said, for the sake of saving time, deal with this matter simultaneously. Justice Kuhn said, no, I'm not going to do that. I'm going to deal only with the 106. And if you want to bring the issue of removal of Mr. Downer, it will be done separately. Now we're doing that which Justice Kuhn said must be done. And we're told it's Stalingrad. The very people who said, let's do it together so that we save time. And you'll find that at paragraph 14 of our pleadings, my Lord, where Justice Kuhn says the following in his judgment at paragraph 120. The further alternative basis contended by Mr. Zuma would presumably be a separate substantive application for the recusal or removal of Mr. Downer as one of the prosecutors. There is no such application before this court. The special plea in terms of 1061H of the CPA is the only issue. In other words, we lost the bid to try and have these things head together. And it was, by the way, the prosecution that was insisting that this is not before the court. But now they turn and point at us as the people who have... it's ridiculous. As the court pleases me.
Yes. I'm sure you'll appreciate the fact that I won't be in a position to give judgment today in this matter, so I have to reserve judgment.
Yes,
but I'll do the best I can to try and speed the process up. Yes.
My Lord, I am in possession now of the original application that has been brought by the second accused. It has been issued out of this court. I beg leave to hand same up. I apologize that it didn't reach you via email.
But is this the way we litigate? I don't think that's the way we're supposed to litigate. Have you served that, have you handed it to the registrar? Is it in the registrar's? Yes,
that's my understanding, was attended to. That was attended to this
right,
morning, but we were all here unless the court would like us to follow in that process. But we thought we were all present if we could hand it up.
All right, what do you expect me to do? You tell me, what do you expect me to do? Because apparently, is that a founding affidavit?
It is the application together with the founding affidavit.
Together with the founding affidavit?
Yes.
And the state is going to have to respond to that?
The state would then need to respond to it, and we will have discussions with the state as to time periods to file papers and the like.
Why don't you do that separately?
We will attend to that separately.
Mr. Breitenbach?
Well, it's correct that this application was emailed to the state yesterday afternoon. Mr. Downer informs me he's had a chance to read it. I looked simply at the notice of motion and noticed that it provides that the state has a period of 10 days within which to indicate its attitude. and should it oppose another 15 days, those being both court day periods, to file an answer. I have had a discussion briefly with my learned friend for the second accused this morning, indicating that if the state's decision is to oppose this application, then we will simultaneously with conveying that also suggest a time frame, which will obviously be subject to your lordship's approval. I've also heard my learned friend Mr. Mpofu today indicating that his client may join this application, and we would obviously then direct that correspondence to them as well. It would obviously be of great assistance to us that if they were to be joining this application, that they would deliver their papers in support of it. I would imagine they would probably have to bring an application of their own, so supported so that we can deal with everything together. But it's just very early in the whole process, and speaking for myself, I haven't read it, so I can't say anything meaningful in that regard, and in any event would require instructions.
Yes, Mr. Mpofu.
My Lord, very briefly, yes, I agree with my Lord friend, Mr. Breitenbach. We're in the same position. My Lord, as I understand, the application has been duly filed. So my learned friend simply wanted, I think, for the convenience of the court to put it in the court file. I don't think she expects anything else, because we all agree, my Lord, that the timelines, if we deviate from the normal timelines, it will be negotiated between the parties. So, my Lord, yeah. So, the only thing I can say, just tongue in cheek, my Lord, is we're likely to oppose the application because on the basis of Stalingrad. As the court pleases me.
Indeed, my Lord, we have had those conversations with my learned friends, and we were just asking to hand up the application to the court.
Or we can give it to the registrar.
As the court pleases, my Lord.
Court adjourns.
Okay.